This is the planning board meeting for Thursday, May 14th, 2026 is called to order at 7 p.m. This, of course, is a continuation from the meeting on April 9th. First thing, roll call. Dr. Benoit?
Here.
Mr. Hammond?
Here.
Mr. Menard?
Here.
Mr. Porter?
Here.
And the chair is here. We have minutes from the April 9th meeting. I'll give you a moment to review those, make any questions or comments.
I'll make a motion that we accept the minutes as presented.
Second motion. And we have a second. Those in favor?
Aye.
Opposed? No. The meeting minutes from April 9th are accepted as presented. Next item, disclosure. Does any planning board members have anything to disclose on the matters before us this evening?
Mr. Chairman, as a direct abutter, I will be recusing, but I do have a letter from the Rhode Island Ethics Commission stating that I may speak as a private citizen.
Absolutely. Okay. Thank you. Anyone else? No? Next time, any planning board members need to disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning the merits of any application presented this evening. No? Okay. So with that, and with Dr. Benoit's recusal, the voting members this evening will be Mr. Hammond, Mr. Menard, Mr. Porter, and myself. Before we jump into the topic at hand, I want to set a couple of expectations for everyone that's here. As you know, especially for those of you that participated or watched the last meeting, there's a lot of new documentation requested, much of which we've received. So there's been a lot to review. There'll be more material presented this evening that will undoubtedly raise questions. The public hearing was continued and therefore will be reopened at some point this evening. Some of you may not have spoken. Some of you may want to speak again on new questions and comments. Lastly, the planning board is working on scheduling a meeting for an executive session with the trust attorney so that we can learn about the things that happened when Attorney Kelly was an intern from law school, and my son wasn't born yet. So it's important information that we get as background because it's from decisions made before anyone on this board was on this board. So we need to have that. We'd be remiss if we went forward without getting that information. So as such, the first expectation I'm setting is that there will be no vote this evening, and the meeting, this project will be continued to probably June 25th or perhaps July 9th. But it will be continued. The public hearing will remain open and will be continued to that meeting as well. Secondly, because of all that I just said, and because we know we're not going to vote and therefore not continue, we're also not going to extend tonight's meeting past 10 o'clock. I know that's very disappointing for all of you, particularly the planning staff themselves, because who doesn't like a 14-hour day when they can get a chance, right? But so as such, you can expect the public hearing to be winding down about 9:30 or so, to give us time to wrap up any open issues, identify any more homework that needs to be done by anybody, et cetera. All right? Great. So with that, I'll turn it over to the applicant.
Thank you for the compliment, Mr. Chairman. I wish that was the case, but it's been 47 years practicing. There was quite a few questions that were raised at the last meeting concerning condo association versus homeowners association, and I'd like to clear those up if I may, and I sent some correspondence into the board. Condominium projects, as we probably all know, are controlled by condominium association pursuant to Rhode Island General Laws 34, 36, 1, 302. And that statute identifies condominium associations and homeowners associations as one and the same. However, there's quite a bit of difference. There's a reason they call it a homeowners association. The members are owners of homes. Condominium association, the owners or residents only own their condo, and the reason. All the common space, accessory buildings, land, et cetera, are owned by the condominium association. And condominium association or condominium project is established by the filing of a declaration in the land evidence records. Now, condominium associations and homeowners associations have similar powers in regard to the control of the development. As I said, the condominium association owns all the land and accessory buildings, and the residents only own their condominium units. Both associations have the authority to assess individual residents for maintenance and other items associated with the operation of the condominium association or the homeowners association. And both associations have the authority to assess assessments, and the associations have the authority to place a lien on their units. One of the largest differences, or most substantial, is that a condominium association owns the roads. They're private roads. I've never seen one that wasn't. And the homeowners association does not own roads. They're always public roads. The condominium association obviously is responsible for the maintenance of common areas, trash pickup, plowing, et cetera. On the other hand, homeowners associations are responsible only for such as open space, or if there was a joint sewer line or sewer pump or whatever, which was in the development, they might be responsible for that maintenance. Both associations provide insurance coverage for applicable areas and also the common areas. Homeowners association is typically responsible for maintenance of any open space or common areas. As I said, it does not own the roads and is not responsible for their maintenance. There was some question as to whether we're going to be private roads in this development or public roads. Since 2005, when this subdivision was first proposed, there has always been public roads for this development. There has never, ever been a discussion concerning this being a condominium-type development where the condo association would be, in fact, the organization maintaining the roads. The open space and any recreational fields in a homeowners association would be the responsibility for the homeowners association. It would also be responsible for drainage pipes that leave the public right of way, drainage ponds, and other stormwater facilities outside the public way. And the town would have no responsibility for these items. Now, until the roadways are accepted by the town, all maintenance of the roadways would be solely the responsibility of the developer. And this would include plowing, repairs, stormwater management facilities, both in the road and in the right-of-way and outside the right-of-way. As I'm sure you all know, after acceptance of the roadways by the town is then responsible for maintaining roadways and other stormwater facilities only in the roadway, just like any other subdivision. I'm sure you've had many before you. Now, there was also some question about trash pickup. Well, the residents in this development are going to be paying taxes to the town just like any other homeowner. And it should be, of course, the responsibility of the town. Just like any other homeowner, they're entitled to that. Now, another important thing we heard, and this has been repeated quite a bit, I've been hearing this since 2005, that this project is a gravel removal operation. It absolutely is not. The only material that would be excavated is as allowed by the zoning code. And the zoning code specifically allows grading land for the construction of a roadway, extraction of earth for a subdivision in accordance with the plat plan duly authorized by the town. Earth removal is also allowed for construction pursuant to building permit, and earth removal is allowed by excavation in the connection with lawful construction of a building, structure, street, driveway, sidewalk, path, or other appurtenance, as long as it does not exceed the finished grade of the project as approved by the planning board. And that's exactly what we have here. There's a big difference between what will be excavated on the site and what will be removed. The recreational fields have also been the subject of discussion. I'd like to point out there's approximately 140 acres of open space in this development. And this is a conservation development, as you know. Instead of 2 acre lots, they're 1 acre lots. And the purposes under your zoning code and planning regulations of a conservation development is to protect natural resources, streams, floodplains, and wetlands. And that's exactly what we're doing by designating those areas as open space. The other purpose of a conservation development is to protect recreational resources and to provide greater design flexibility and efficiency in the siting of services, infrastructure, wastewater disposal systems, and to reduce the length of road, utility runs, and amount of pavement required, and therefore stormwater runoff. This subdivision accomplishes all of those goals. In addition, in regard to the recreational fields, which have been the subject of discussion, and as Mr. Preve and Mr. Resnick will tell you, they have been significantly reduced in regard to the board's concerns. Now, under section 344.51 of your zoning code, specifically allows as a use by right subdivision parks, playgrounds, community centers, recreational facilities, other similar structures of a non-commercial nature designed for the use of the residents of the conservation development and their guests. There cannot be any question that that's exactly the purpose of these recreational fields, for the use of the residents only. This is, the recreational fields are, as I just read, specifically allowed as a use in this zone and in this subdivision. I want to point out that this board, under state law, under your own zoning code and planning regulations, and case law, immense case law of the Supreme Court, this planning board does not have authority to prevent an allowed use under the zoning code under any circumstances. You do not have the authority to do that. And it's not a question as to whether you like the recreational fields or you have speculation that it might be a gravel operation. That is totally immaterial. The use is specifically allowed. Now, we were asked to take a look at the yardage that would be excavated and or removed in this subdivision. And pursuant to the current conservation development, it would be approximately 750,000 yards of material excavated, not removed. Of that 750,000, about approximately 350,000 would be used on site for road-based septic systems, fill in low areas. So the total that might leave the site, this is all approximate, be approximately 400,000 yards. The roadways in this conservation development are 11,800 feet. If this were a conventional subdivision, the roadway length would be 22,500 feet of roadway, double the length of the roadway in this subdivision, increasing stormwater runoff, impervious surface, and the town's obligation to maintain these roadways. The frontage requirements under this, the regulations for conventional subdivision are 200 feet, whereas in a conservation development, they're only 120 feet. Obviously, the reason is to, as the purpose of the conservation development is to reduce stormwater runoff, et cetera. Additional, with 2 acre lots, you're going to have substantially more clearing and excavation as a result of the lots being twice as large as this subdivision and the roads being twice as long as this subdivision. Now, if this was a conventional subdivision, approximately 1.3 million yards of material have to be excavated, not removed, excavated. Approximately 400,000 yards would be used on site, which would mean there would be approximately 950,000 yards that have to be removed from the site, double what this development will cause. As you know, the construction of this project is specifically allowed by your zoning code. And I don't think it's up for discussion that this site has substantial grade changes. There are hill areas, there are valleys that requires cuts and fills. Now, the board in the past, and all of this has been discussed since 2005, believe it or not, we were asked to try and reduce the cuts and fills, which we have to the best of our ability. But there's no other way to install roads, houses, and improvements but for excavation of the earth as appropriate. And believe it or not, we're not aware of any way to flatten hills without significant excavation. It's pure common sense. If anyone has an idea on how this could magically happen, we would be happy to hear about it. Now, in regard to the history, this is one of the most unique and bizarre subdivisions that I've had in 47 years. It started in 2005, and the application was filed 2005. 1 week later, the town council tried to block it by enacting a moratorium on subdivisions. We took that to court, and it was immediately ruled illegal. We then came back to the planning board to proceed with the subdivision. The planning board at the time insisted the applicant perform an archaeological study at master plan for the entire site. That was not a requirement, and is not a requirement now by state law or the regulations. So the requirement was in violation of state law, the town's own regulations, and of course, it's not appropriate at master plan. I think you all know that. We now are at a preliminary plan, and we have done that. We studied the entire site, not just phase 1. Now, the planning board, in I think it was 2012 or 14, when they demanded that an archaeological study be done on the entire site, had before it a study that had already been done by PAL, a very reputable firm located in Pawtucket. And it was done in the presence of Narragansett Indians. The subject, which has always been the subject of speculation, is whether piles of rocks on this site are Indian burial grounds. They are not. PAL excavated one of them with the Narragansett Indians present. There were no bones or any other evidence of Indian culture under those rocks. And the rocks were, piles of rocks, were determined to be created by farmers and other settlers piling up to get them out of the way of their activities. Despite the fact that study had been done previously, Planning Board continued to insist on an archaeological study of the entire subdivision prior to master plan. At the Planning Board meeting on the master plan, a so-called professor from URI, Mr. Mealy, was presented by the Conservation Commission. Also illegal, the town council authorized the Conservation Commission to engage Mr. Mealy and paid for it. As you know, the town council has no participation in the approval of a subdivision. It's solely the authority of this board. The planning board is the only entity that has the authority to deny or approve at this point. When Mr. Mealy was presented at the hearing, I inquired before I allowed him to testify. I asked to inquire as to his expertise. I inquired as to whether he had any experience in Indian culture or archaeological studies of New England Native Americans. He replied, no. His expertise was in Peruvian Indians. Now, I calculated that. I think that's about 3,000 miles away. So he had no expertise. Despite that, the planning board accepted his statements. And as a result, the subdivision was denied. Mr. Mealy also said that he had excavated a pile of rocks on an adjacent property and found bones, and he believed they were human bones. Well, about 8 months after the denial, they were determined to be pig bones after being analyzed. The subdivision was denied based upon the demand for an archaeological study. We took an appeal, and we sued the town for damages for a wrongful denial. It turned out after we took depositions that Mr. Mealy, who was a so-called professor at URI, in fact, was a fraud. He did not have a PhD. And it was reported to the state police, and he was charged with obtaining money under false pretenses from the state of Rhode Island. And even worse, even more egregious, it turned out that prior to the planning board hearing on master plan, 2 members of the planning board, including the chairman, met with Mr. Melly, with the town solicitor for the town council, and the planning board, along with Mr. Smith, who was the peer reviewer. And they planned out how to deny this subdivision. I don't have to tell you that's an egregious violation of constitutional rights. When this was discovered, the town immediately settled. And the consent judgment, as you know, you have it, obviously allows this subdivision to proceed, and it is subject to any changes in state law or federal law. And as you know, those have changed in regard to the requirements for a preliminary subdivision. State permits, such as DOT permits and DEM permits, are not required for an approval at preliminary. And the state law specifically sets that forth. Now, the chairman asked if anyone had any communications outside of the hearing and the process, and I noticed that there were a couple of members that did not respond to that. I would ask that the chairman poll everyone to make sure that doesn't happen. I don't want to run into a situation. I don't make this statement as a threat, but it's a fact. After 21 years, 2 generations of owners, if this project's denied, we will take an appeal, and we'll take further action than that, probably the same action we took in 2014, and that would be an action for damages for wrongful denial, violation of our constitutional rights. This project has been before the planning board for 21 years, and there is a strong commitment, bulletproof commitment, that the owner is going to go forward with this subdivision no matter what. I don't have to tell you that a judge hearing this matter on an appeal is going to be fully appraised of the conduct of the town's planning board at the time, and I think it's very safe to say, in fact, I'll guarantee, the judge will not look favorably upon what's happened to this subdivision in the past. If the denial is, if there's a denial based on recreation fields or speculated earth removal, that would constitute a complete violation of the town's zoning code, and that basically would be an intentional denial. Obviously, as others have done here in this town, we would seek our fees under the Equal Access to Justice Act in addition to an action for damages. I understand the town recently had to pay legal fees for an applicant whose project was wrongfully denied. The only thing the applicant is looking for is a fair hearing based upon competent evidence in the record. The only criteria, and this is well settled, and I'm sure your town solicitor will tell you, is whether there's competent evidence that's been presented to the board, such as experts and other knowledgeable individuals with experience, and whether it's complied with the regulations. You cannot substitute your judgment for our experts' opinions. You cannot substitute your lay opinion for any of the experts or any of the fields of subjects that are required expert opinion. Addition, it does not matter, and you cannot take into consideration the number of objectors to this development, whether they be friends or neighbors. There could be 5,000 objectors to this project, but that cannot legally be considered in making your decision. Again, as Mr. Resnick indicated at the last meeting, the number of school children is totally irrelevant, and that's state law. I would point out that over the last several years, as Mr. Lombardo will point out, there's been a 100 student reduction in students in North Smithfield. I would respectfully suggest that to date, we have complied with all the regulations. We've provided all of the information you've required. And I frankly haven't heard any competent evidence to suggest it's not in conformance with the regulations. The dozens of Supreme Court cases that clearly indicate that if an application or a project meets the subdivision regulations, the planning regulations, it has to be approved. I'd also like to point out that, in fact, the only standard in regard to the approval or denial is set forth in state law and your own regulations. Any decision has to be supported by competent, legally competent evidence in the record. If it is not, the courts have uniformly, in fact, overturned decisions not based on that standard. Now, I would ask that the board treat this applicant fairly like any other applicant. Yes, it's a large development. It's being phased. We anticipate take approximately 7 to 8 years before this is built out. Houses just don't sell that fast. You look at the number of houses that are sold in North Smithfield, you'll see that it could never be absorbed, and it's not going to be built that way. And that's why it has been phased. So I'd be happy to answer any questions you might have in regard to what I just stated, and Mr. Resnick and the other experts will be addressing the items that the board requested at the last meeting.
Okay. Any questions from the board? For Mr. Kelly? No? No questions? No, we're good.
Thank you.
Thank you very much.
Good evening, members of the board. Mike Resnick again. Nice to see you again. And we're joined with 3 of our experts. So we've brought back our traffic expert. We have no plan on doing a presentation in chief, but he's certainly available for questions. Mr. Preve is here, our civil engineer. He's going to go over a variety of matters. And we also have our fiscal impact expert, Joe Lombardo, who has provided a supplemental fiscal impact statement and is going to testify in chief. So I just want to go over a couple things for housekeeping really quick, because there were many requests from the community as well as the board for deliverables that we provide. And I just want to make sure that everybody's aware of what has been made part of the record since the last meeting. And of course, Mr. Preve is going to discuss some of these matters in some detail with some demonstratives. There's a nutrient loading memo that's been provided. There's been a master plan, yield plan, to demonstrate to you the difference between the conventional and the conservation, as Mike had mentioned. There's a recreational field exhibit, which we'll go through, which shows reduced size of the fields. And Mr. Preve's also going to discuss some augmentation of the parking that we think will be a benefit in the buffer to the neighbors and the disturbance of the area. In addition, we have some updated correspondence from the town and Rhode Island HPC. We've provided an archaeological study that was revised 9/22. A letter from Mr. Danta specifically addressing some of the comments that were raised about one of the purported battlegrounds, or the question of whether the battleground was on this property. Again, there's an updated fiscal impact summary and report. There's a lighting plan that was requested. Attorney Kelly had referenced that in his recital of the difference between condominium and HOAs. There's also a letter to that effect that was sent. There's another letter that was sent regarding your ordinance and the earth removal in the recreational fields. There's some correspondence that we received from one of the associations or groups, and our response there too, as well as the history of the requests for approval and extensions for this project. So that's generally the updated materials that you have. With respect to just kind of priming the main issues that were raised previously, one was the archaeological issue, the Battle of Nipishuk, if I'm pronouncing it correctly.
Nipsachuk.
Thank you very much. And anyways, Mr. Dantas provided us a letter April 27th, 2026. It's made part of the record. and I'd like to read it verbatim to the board. It'll be very short, and it's addressed to our office. With regards to the question of where the proposed development is in relation to the Battle of Motilty Swamp, also known as the Second Battle of Nipsachuk, which took place on July 2nd, 1676, part of King Philip's War, June 1675 to April 1678. You'll note that the location of the battle is confirmed by the Research C. McBride at 2013, and you do have that map that's been appended to this correspondence, is, I quote, entirely outside of the project area on the other side of Douglas Pike, and that's figure 1. And there may be a question as to what was that comment from the state agency asking for that supplementation. Why was that supplementation requested? And to that, Mr. Donta responded, we originally neglected to include the battle in our discussion of National Register of Historic Places resources near the project area on page 13 of the above referenced report dated May 2022, although the battle was discussed in detail elsewhere in the report. We provided a corrected report revised in September of 22 that does include the battle within that paragraph. In any case, the proposed development does not include any part of that historic resource, right? So I think that we've addressed that satisfactorily, transparency reasons, but again, that is the purview of that state agency. So that was issue number 1. Issue number 2 was relative to nutrient loading, groundwater protection, septic concerns. Mr. Preve's going to get into it in detail. I would characterize it as concerns that nitrogen loading would have an effect on private wells, groundwater contamination, and GA groundwater classification. Very briefly, RIDEM OWTS program has primary jurisdiction over nutrient loading review. In fact, they have original and they have all jurisdiction. The project exceeds RIDEM's minimum standards for 30,000 square foot lots. The subdivision-wide nitrogen compliance is expressly permitted through nitrogen credit through land. Approximately 164 acres are preserved as nitrogen land credit. And lastly, the GA groundwater classification does not prohibit development, and the project is not within any groundwater overlay district. So that's number 2, and we have some demonstratives that Mr. Preve will go over. I'm not going to go any further into the recreational fields earth removal. I think that's been appropriately addressed. The HOA condominium concern has been addressed. We discussed the conservation design, the density related to that, the concept of open space, and I think that Attorney Kelly may not have mentioned, but I think the board is aware that we have set up a dialogue with the land trust to discuss potentially them taking over control of that open space, but of course it would not be open to the public. It would be true conservation land. So those are some discussions that are ongoing. One thing that I wanted to comment, because I think that all the community and I think the board members are aware, there's the proliferation of comp permits in this state, right? Low and moderate housing. And I just want to give you an idea of the type of density that would yield. You'd be looking at 3 homes per acre. Here you have 1 home for every 2 acres. So it's just an understanding that this is not a dense project compared to the density that this property could be susceptible for, and particularly this town could be susceptible to. And it's just something to understand that, relatively speaking, this is not a dense development. There's a lot of property. With respect
Could
to...
I ask you a question on
Yes.
that? You just said 1 home for every 2 acres.
I say under a comp permit, you could have
3 homes
yeah,
per acre.
and here, if you do the calculation, including the open space, and I'll leave the mathematics to Mr. Preve, but I believe that it would be, I believe it is a half an acre, correct? I'm sorry, 2.3. 2.3.
It's 30,000 square feet, isn't it? That's 2/3 of an acre. Correct.
Right.
Okay. All right.
Excuse me if I misspoke. Just final couple items, fire access. There was a concern raised, I believe, relative to emergency access, cisterns, and phasing. I believe your planner has confirmed. The fire marshal reviewed the plans and identified no issues with the cistern placement. Mr. Preve will talk about some of the things we're going to acknowledge: infrastructure, timing, operational conditions, and he'll discuss the emergency access route again and the knock box. There was also some comments about public process. This has been an incredibly transparent process. We've agreed to a continuance before we even showed up to this hearing to make sure that there was no argument or comment that the materials that we recently supplemented, that there wasn't enough time for the board or the community to review them. So we welcome this process, but as Mr. Kelly indicated, we need to be treated fair. This is a different project than is normally before the board. It comes with more baggage than just a master plan approval. It comes with something very serious, and we take it very seriously. So with that, before I think Mr. Preve gets into some of the details and some of the demonstratives, I think it makes sense to have Mr. Lombardo come up, and if he could go through the fiscal impact statement, and hopefully we can address all the testimony that he might need to provide this evening. And Mr. Lombardo, if you wouldn't mind, if you could please just describe your experience and your credentials to the board.
Yes, good evening, Mr. Chairman, members of the board, folks here this evening. My name is Joseph Lombardo. I'm a land use planner. I've been practicing since 1977. I'm a member of the American Institute of Certified Planners, and I've been preparing fiscal impact studies for about 30 years. There's a variety of different ways that we do them. I was the municipal planner in the town of Hopkinton, the town of Richmond, the town of Westerly, and also I did some work in Groton, Connecticut. So I'm familiar with working with the regulations, and I'm familiar with working with planning and zoning boards, and that's really my background, Mike.
Okay.
And Mr. Chairman, if you would, I'd like to qualify Mr. Lombardo as an expert in fiscal analysis.
It's fine.
Thank you.
Okay, good evening again. So what I'd like to just explain to the board is early on in this process, I was asked to prepare what I would call a preliminary look at this project. And this project has had several different versions of it. And at the time, we were asked to just look at estimating school-age children and population, and I added in what the potential for the revenue that would be collected by a project based on the number of homes, average selling price, and your current tax rate. Now that this project has progressed to the preliminary, through your planner and through the client and the applicant, was asked to do a more complete fiscal report, which would include not only the projections of revenue, but also some projections of cost of education and cost for municipal services. So what you see here is the result of that request to make it more complete. I used data that was provided for me, some of it from the builder and the developer, some from the town, some from Rhode Island Housing Works, some from U.S. Census data. So I try to cite those sources in here, and I have some information in my addendum when I looked at trying to estimate school-age children. So the summary of the report really says that there's estimated revenues of a little over $1 million, $1,086,000. There's estimate of 327 individuals living in this project if it were fully built out today, and that would include 75 school-age children. So that's the estimate. It's as if it was in place today with current data. Now we know, as both attorneys have explained to you and you're aware, that this is going to be phased out over a number of years. So that would be a difficult process to try to estimate every year what your budget goes up, what the school budget goes up, how many school-age children might be there, those kinds of things. So we really just do it this way. I don't want to say it's simplistic, but it's the way that I've been doing these estimates for many, many years. It just gives the board an idea what it looks like. And I can explain to you a little bit about how I arrived at those numbers. The first thing is to understand the type of housing being proposed. If you have 3- and 4-bedroom single-family homes, there's a projection based on a variety of sources, which I cite in the report, of approximately 60 school-age children for every 100 units. And that number is fairly well substantiated through the years and through the sources that I list in here. So if we take that number by the number of housing units, that's how we end up with 327 individuals, 75 of which are school-age children. On the revenue side, first looking at looking at the projected sales price of these units. Now, we all know how much housing has gone up in the state of Rhode Island everywhere in the last few years. The developer is estimating these units to sell at approximately $750,000 per unit. At your current tax rate of $11.50 a thousand, it generates about $8,600 per unit, and that's how we get the $1,086,000 in revenue. Now, of course, that doesn't represent one-time fees that the town collects. The building permit, site plan review, going through your board, and then building permits, of course, also generate income to the community as time goes on. Now, in order to project the school impact to the school system, we currently have, as of October 1st of 2025, every year, the Department of Education does a census. So I have a table 4 in my report that actually shows you how your enrollment has changed over the last 11 years, whereas you had a high of 1,734 in 2017, and in 2025, in the current year that's ending, it's 1,646. So about 90 students less than before. And if you look at the trend, it's up and down over the last 5 or 6 years, but it's averaging somewhere around 1,640 students. So I use that current number of 1,646. I look at the school budget for the current year, which is $22 million, which is the net cost of the community, because you receive approximately $9,500,000 from the state of Rhode Island, so that brings your cost per student down. But even with that, it's still pretty high at $13,445 per student. So that's how we're going to indicate what the total cost for your education is for this project. On the municipal side, I took, based on some discussions about the types of municipal involvement on this project site, I took the major services that the community provides: police, fire, DPW, and highway. And I took that budget number, which is approximately $13.5 million, and I divide that by the number of people that live in North Smithfield, 12,500. It's approximately $1,075 per resident to provide those municipal services. Now, we know that some of the municipal services won't necessarily apply here. It's been explained to you about the homeowners association taking over some of those. So I've reduced that number down to $860 because you don't have to do fully everything in this development. So if we multiply the 860 times the 327 individuals, that will give you the municipal expense. So what you see on the last page, table 6, is a comparison of those numbers. The municipal cost at $281,000, the school cost at $1 million, total cost of $1,289,000, with an estimated revenue of $1,086,000, which shows us a deficit of $203,000. I will comment that I've been doing these types of reports for many years and for many different types of residential developments. And it's been my experience that almost without exception, any single-family home development will usually show a slight revenue loss to the host community. That's just a simple function of school-age children primarily, but if this were 2-bedroom condominiums, it would probably show quite a bit of a surplus. It's really related to that. So with that, I hope I answered some of the questions that were raised by the board and others before tonight. Try to make this as complete as possible and give you an idea. But again, as it points out, it's a checklist item. It's informational for the board to understand what it might look like if this was sitting here today 100%. I guess from a point of view of that this would be phased over 8 years, 9 years, the impacts to the community would be incremental over that time. And school-age children being added would be acclimated into the school system, divided, between your elementary, your middle schools, and your high schools. So you get an idea, really, what the project might look like from that perspective. I'm happy to answer questions now or later, but I just wanted to give you that overview of the report. Thank you for your time.
Thanks. Any questions here? I just have one.
Sure.
What's the target price range for the homes?
Yeah, the number that was given to me probably within the last month is 750,000.
Oh, okay.
Mm-hmm.
Thank you.
Just one wrap-up question, Mr.
Oh,
Chairman.
I do have a question before you.
Sure.
Go ahead. Throughout the report, there's references to the town of Smithfield and to the town of North Smithfield. I'm not just assuming that that's a typo.
Did you get the latest report?
The one that's on the website references both North Smithfield and the town of Smithfield.
Does it say April 2026 on it?
Yep, that's,
If it is, it was a mistake. I thought I corrected all of those on this. I'm looking right now.
okay. No, I just wanted to make sure that we're,
Oh, no, it's definitely North Smithfield, but I'm looking, all the tables are all labeled.
yeah, on page 2, we have the town of North Smithfield will realize total estimated revenues of $1 million and blah, blah, blah.
Right.
And then the third paragraph says the town of
Oh, I see
Smithfield.
it. I missed putting down North there, right.
Yeah,
Okay.
and-
It is North Smithfield.
Yeah, okay. And that's throughout as well. There's the first paragraph that says the town of North Smithfield.
Yeah.
And so just if this is being entered into the record, I just want to make sure
Yeah,
you're
we'll
all
make that
set.
note. Thank you.
Yep.
Thanks. Okay. Mr. Resnick?
And Mr. Lombardo, with that correction that was brought to your attention, your report, your testimony today, they have reasonable degree of certainty in your expertise as a fiscal impact expert.
Yes, it is.
All right, and just to be clear, all of the data, and that was a scrivener's error, it was meant to refer to North Smithfield, correct?
Absolutely. Thank you for pointing that out.
Thank you.
Great.
All right, and with that, Mr. Chairman, we'll call Mr. Preve to go over the demonstratives and some of the items I had mentioned.
Good evening. For the record, Eric Prevey, P-R-I-V as in Victor E. I'm a registered professional engineer with DePrete Engineering. Offices at 2 Stafford Court in Cranston, Rhode Island. What I'd like to do tonight is go through kind of a couple of the items that we had put together. I will start off with the nutrient loading. That was one of the items that was requested. We were asked to prepare nutrient loading of a general summary that wasn't highly too technical or such, and so that's what we tried to do. I'm referencing the May 5th document. I assume everybody has that document as well? Okay, thank you. The 3 points that we had coming in on the nutrient loading were based actually really on two things, and then I added some extra content at the end regarding the GA classification. But regarding the nutrient loading, obviously DEM, the Department of Environmental Management, is the sole source for reviewing and approval of on-site wastewater treatment systems, septics, as we have in this area. And with that comes the nutrient loading as well. They have very specific conditions, and I had cited in here. I'm not going to go through the entire document, but Section 6.45, which is nitrogen loading areas in on-site drinking water wells. So very specific to this exact areas that have on-site drinking water wells. And Section 6.5 uses a basis of 345 gallons per day for every half acre, for every 20,000 square foot of lot area. Okay, that's the equivalent of a 3-bedroom dwelling. That's what they use as a basis. That translates, and it even says directly in their regulations, to 1/6 of an acre per bedroom. That is what the science has proven when they had developed the regulations of what is safe levels as well. So 1/6 of an acre per bedroom is the standard that is in the regulations. For the 4-bedroom dwellings that we are proposing, that is a 30,000 square feet per lot. So on the lot level, each individual lot has a minimum of 30,000 square feet. And that is in line with what DEM requires for nutrient loading analysis as well. So we are, and again, the 30,000 square feet per lot is the minimum that we have out there, with many of the lots being even larger than that. So on the lot level, they are already compliant. Then you put on On top of that, we have 164 acres of open space that will be protected and put on with conservation easements. That is also used in the next section that I added on here, which was 6.45F, which is nutrient credit land. And that's areas where you can, they recognize that in areas where you have reduced lot sizes in conservation developments, cluster developments, every municipality has a different name for what it is, that you can use the open space as well, because it's an overall density. There's obviously large amounts of area of the open space that also are receiving rain, recharging the groundwater aquifer, diluting and putting it as well. That's a natural part of it, right, as well. So on top of that, we also have 164 acres of nutrient credit land that are also going to that calculation as well. So meets it on the individual lot level, then adding on an extra safeguard, kind of a belt and suspenders approach. We also have 164 acres of open space that also are used towards dilution without adding additional nutrients. There's no nitrogen being added in those open space areas. So that was, I think that was an important first fact on there, because obviously DEM is the sole authority. But then I wanted to add in also, I think it's really important, because I am fairly confident I was not on the board, or I was not on the ad hoc committee that developed the conservation regulations in the town of North Smithfield. But the town of North Smithfield has, in the conservation regulations, set forth what the sizes for those are. And citing directly Table 1 of 340-4.53, it establishes a minimum lot area of 30,000 square feet for single-family dwellings that are served by, it says ISDS, individual sewage disposal systems. That's the old terminology for on-site wastewater treatment systems, and private wells. So at that time, I just wanted to add, because I think it's important. I think the town at that time also recognized that that was, you wouldn't be promoting and encouraging conservation developments at a level that would be unsafe levels as well. So I wanted to add that. I thought that was an important fact as well to add in there as well. The last part that I put in there was the groundwater classification. That is not directly related to nutrient loading, but it was something that we heard several times through neighbors and abutters that were saying, this is under a GA classification groundwater, right? So I just wanted to add some extra facts in there, because I'm not sure that everybody was aware of what the GA, what that even means, groundwater classification of GA. So I added those. And GA, so it goes GAA is the highest level of drinking water, then GA, GB, GC. So GB and GC typically are in more like landfill areas and areas that you would not have drinking water as much. GAA are within drinking water aquifer areas, ones that are directly supplying drinking water wells, such. Approximately 20% of the state is GAA, and approximately 70% of the site is GA. So between either being GA or GAA, the two highest there, 90% of the state is of GA or GAA quality. I think it was important to add that because, you know, it was it felt like the inference was that this was some sort of sacred water supply, and I just wanted to clarify that and add some facts to that, because if you look at the groundwater map for the town of North Smithfield, it is effectively all either GA or GAA quality with just a couple small little blips of a GB, and I assume that was probably either a landfill area or something. So I just wanted to add those facts. I thought that was important to add because there was some, what I felt were almost misconstruing what the land was as well. That's on the nutrient loading. If you'd like me to pause and take any specific questions on just that, or I can keep going with the other things that we were doing as well.
Mr. Porter. CJ, can we move this podium so we're not blinding
I'm good.
the applicant?
I'm good. Thank you, though.
I've been in that spot with the council here, so I know how distracting it can be. And
I'm good. I
blinding,
appreciate it, though.
But no problem. All right.
Was there anything specific? I just wanted to pause in case anybody on nutrient loading before I move. Okay, thank you. So the next part that was requested, and I'd like to go through this map right here. So this is a different variation of the map that we were showing at the last meeting. So this is the overall plan showing the entire subdivision. Again, on the outside, you can see all the green areas are the open space areas. Again, 59% of the site, over 50% of the site, 59% of the site as preserved open space areas. What we added here is what we promised we would do. We added some phasing on here. So we made it color phasing so it makes it quick and easy for people to see and such. And then what we added is we also added a key. So not just for the visual here. So you can see phase 1 are these lots right here. And then it's hard to see because it's on a big screen, but you guys have it as well. The main road is also that same color as phase 1, so you can see there. And then we also we wrote it right over here on the phasing legend as well. So that includes the specific lot numbers and the linear footage of road that is included with that in that phase. So you have phase 1, phase 2, and such. So that was what we promised and what we provided as well. So, but this plan has other items as well that were requested. The limited disturbance was requested. There was asked where the tree clearing would go and where the tree cutting would go. So this plan also has that. We felt this was the most appropriate to kind of see everything quickly. And so this orange line, and we added the label right on here too. This right on the legend, this orange area over here, that orange line is the limit of disturbance, so tree clearing in this area. And again, that shows what we need for either stormwater basins and for development of the lots, the individual lots throughout. So you can see the orange area. So that was something that was asked. What is the tree clearing extent and where does that go?
But that tree clearing includes a lot more than just for the lots. Obviously, you have to clear here. And,
Yep.
you know, again, we would hope you clear what you need and no more than that, but makes for a more attractive development anyway. But along the emergency access road, isn't that the same orange line?
Right here?
Yes.
Am I pointing in the right spot that you're talking about?
Yeah,
first of
there and all
Yep.
along that.
Yes.
So does that imply that everything to the right of that would also be cleared?
To the, everything within the inside.
No,
And
I'm looking at
I'm sorry. Yep.
Take the orange line.
Nope, just this, so it's just this.
Oh,
Right here, this
'Cause-
narrow area. There's an existing path today. And so it would be between these two areas.
oh, it's between the two orange lines.
Between
I got
these
it.
two.
Okay, thank you for clarifying that.
Yep.
Okay.
So for instance, like where I'm pointing right now, in this area.
Yep.
This would be cleared because there needs to be, we need to do some stormwater in this area as well.
Understood.
This side over here would not be. So where I'm pointing now would
Gotcha.
be not cut. On this inside area is where it would be cut. So that, yeah, I can understand how that's a little confusing as well.
So the fields are sort of nestled within the woods?
Correct.
Yep.
And then what we did with that as well, I think it's, we also added on the trails. So there's existing trails out there, and then what we did is, so we have two keys on here. We have what the existing trails are, and then we have proposed. And the only reason I add proposed was because there was some discussions about maintaining some of the, maintaining the trails as much as possible. So for instance, this trail right here, and I can't actually, hold on, it's hard to read from there. Between lots 88 and 89, for instance, right here, that's an existing trail that comes in this area. So that already, we were able to maintain that. But as it came through here, we're going to sneak it through and come through and just displace it a little bit because it kind of went right through the middle of 58, I believe. Yeah, 58. So we're going to be able to just recreate that so we can keep that path going. You know, there's development that needs to be done, but can we keep it moving so we can have the continuous path coming through here? Similarly for, in this area, we'll be able to offshoot it over here, come back to the road, and then come back over and continue the trail. So we tried to show areas, and that also speaks a bit to the issue of, at the master plan, was looking to reconfigure some of the lots around these areas, and that's how we look to address that one.
Similar to what you just pointed out on the trails, one of the trails goes through one of the fields. Will there be a referee there to blow a whistle whenever someone is on the trail? Or?
I can safely say that part of the, yes, that part of the trail will not be there.
I was going to say, or you could
It'll
go
go
between.
around.
You could go between the two fields. or
Correct,
something. Yeah, okay.
exactly. That speaks to a majority. What I also wanted to show here, and I'll show it on the Zoom, we have a zoomed in one that I'll show also, but Wanted to also show, since the last meeting, there was some discussion about providing some extra, either evergreen screening or such over in this area on the recreation fields. So we have. So I wanted to show that on this overall plan too, just so everyone can kind of see it for the Leonard Drive folks, if anybody from Leonard Drive is here, how we've got that as well. It's also in the next Zoom. I'll speak to it a little more precisely, but I just wanted to add that here. Also very important to note, the size of these fields got reduced from last time that you saw. When we were here last time, these fields were larger fields. We heard what you said at the last meeting as far as providing buffers and some of the impacts in this area. So we were able to narrow up this field over here, pull it away, and really provide a larger separation to the Leonard Drive folks. Actually, can you go to the next plan? It'll be probably a good time to transition, unless anybody had we can come back to that if you need it, but yeah, let's go. Okay, thank you. So just to get everyone acclimated real quick, because you probably haven't seen this, right here is Brookside, and then this is where it would come through here. This is the access path that comes through here, and then it would come and connect over, I'll get out of the way here, to Leonard Drive through here. So we were able to tuck all this in this area here. These fields have been reduced by greater than 50% than previously. So narrowed up. Another piece of that was important, or you requested, excuse me, was showing where that field was relative to topography.
Yeah.
It was only shown on that overall plan that didn't have topography. So now you can see that it's in this flatter area here.
Except for the third one, which is in some of the steepest topography.
Right here?
Yes.
Yeah, well, we had to have the access road come through anyway.
I'm not questioning the access road, I'm questioning the field.
Yes, gotcha.
Because that's what was said, is that the fields would be developed in the flattest areas, and that's true for 2 out of the 3.
Gotcha.
So I'm just curious why that's needed. Yeah, the other thing, I'm just curious from a design perspective, the process that went through that led to designers saying, kids would love to just have some open grass. They don't want a tennis court. They don't want a half basketball court, or a playground even, right? So in case you have, very young children here, that they just need a lot of grass. What led to that design? Because I don't know of any recreational area like Pacheco Park or anything that is limited to a lot of grass.
I can tell you on our end, I'm going to stick to civil engineering world. I'm not the developer. I'm not the person that makes the decisions on what goes out here and what they think is marketable. So I make it work to what was requested of me. So that's all I can answer for you. If you want to ask that, in another way, but I can tell you, we don't do market research into what is being done out there. But
Gotcha.
So
Yours is not to question why. Got it.
make it. One thing I noticed right after we submitted this, and I think it's important, is I noticed it right after we had submitted it. First of all, we put the dimensions on here to show the increases in distances through here. You can see the proposed evergreen screening here. So the way that the topography is in this area is higher than this area over here. So having the evergreen along here should buffer as well for the Leonard Drive folks. Again, evergreen, because obviously we live in New England, we lose trees and we lose the leaves. So providing some extra buffering here to the fields. One thing I noticed once we had submitted was this parking area that's located right here. We kept it here when we were kind of going through the iterations of it, and I said, why were we doing that per se? Similar to what you said from a design perspective, why were we doing that? And I recognized it was because the trail on the master plan was coming from this direction here. It made sense to come off the trail, park, go out to the fields. But now that the path is coming over from this side here, we're gonna place it so I can take this area right here, put it directly between these 2 fields here, which then can tuck in my limited disturbance area in this area as well. So we can slide that over. I can take this parking, and it also makes more sense to have that parking be closer to the actual field as well. So I noticed that right after we submitted. I just wanted to add that as a fact as well.
Thank you.
So this was the other exhibit that we provided. You had asked to look at it with the topography. Obviously, we're showing you where the ponds needed to be located as well. So I don't necessarily have anything more to say on that other than the reduction in sizes, the increase in buffers, so providing greater buffers, pulling it further away from Leonard Drive folks, providing evergreen screening along this area as well.
You guys have any, no?
Am I going too fast? Okay.
Mr. Reeve, who's going to police the access road to make sure that only residents use it?
So
The
it'll have a gate, though.
the emergency road is for residents only, correct?
Correct. It'll have a gate right here.
No, but there's the entrance into the development
Right here?
itself, right?
Yeah, so this would block, this right here.
But so anybody driving into the development, which is public roads and therefore anybody can drive into it, could go out and get onto that road.
Oh, yes, I'm sorry, yeah. So somebody that does not live in Rankin Estates could come on from the main entrance at Douglas Pike, could come through the subdivision, and they could come through to this. In theory, they could, yes. Yep.
Okay, so that's, I mean, it's
They're
stated
not
a number of
checking
times.
They're not checking
I understand,
passes.
right.
Private property, so the police.
Oh, so it'll be up to the residents to police themselves and then, okay, that's why I asked the question, okay.
So, and just to, actually, that's a good point too, because I did testify and I mentioned it, but it's probably worth just real quickly going over while we have this exhibit as well. There would be a gate in this area
Right.
with a Knox box for DPW and for fire and emergency personnel to be able to do. So none of the residents are able to access, they're not going out Leonard Drive. It would only be opened if it was needed for emergency purposes. And same at the end of Brookside here. So the gate would be located here. So you could go back and forth between the fields and such, but the gate would be here so that nobody can go on to Brookside as well.
Gotcha.
So it's worth, I testified to it, but it's probably worth reminding everybody from last time as well. Those were kind of the main points I had. We did include the other two exhibits. We included the old the old conventional yield plan. I thought it was helpful to remind everybody. It had been a long time since we had been back from that. So it's just important to sometimes facts and data gets lost. So I'm not going to speak to it anymore unless you wanted me to, but it just demonstrates what a conventional subdivision is. I don't know that the town has probably even approved a conventional probably in quite a while. Most people are tending to go with conservation developments, smaller lots, preserve land. I did want to clarify, though, when you had asked the question on the lot sizes and with Attorney Resnick as well, I just want to clarify two things here. The specific lot size are minimum of 30,000 square feet. But the density, we're speaking of density. When Attorney Resnick was talking, he was talking about density. And the density of this is 2.2 acres per unit. That's the density, because that open space is still part of.
That's counting the open space, yeah.
It is.
Yeah.
But Attorney Resnick was also speaking to comprehensive permits that are also density of the inverse of that. 3 per 1 acre density as well. So I just wanted to clarify, because it was kind of a back and forth on it. So even though the lot sizes are 30,000 square feet, the overall density of the development is 2.2 acres, which is much larger than what is, this is a 65,000 square feet, right? It's an RA 65, which would be a minimum lot size of 65,000 square feet.
Right.
So much larger than what the town zoning requires as well. That was kind of my general,
Anything else?
what was prepared on my end of things,
Okay.
so.
Mr. Hammond?
I have a quick question. Just looking at the map, the clearing of the tree seems pretty tight along, like, there's obviously the ponds, the house developments, fields. There's a couple, like, random bulges across from field 3 and near field 1.
Could you go back to the other one, please? Yep, thank you.
Yeah, so, like, if you go across from field 3, it, like, kind of juts
Pond.
out there.
We-
Oh, there's a
we still
pond
have to
there?
do-
Sorry. Okay.
So
There's a pond
I
there.
believe you're speaking of this area that I'm circling right here.
Yeah.
And possibly this area here.
Okay, so those are ponds.
Those are ponds.
Okay,
Because
cool.
when we're clearing trees, we do need to still do mitigation.
No, that makes sense. Just on the other one, the ponds weren't on
But,
there.
but
so
why?
that's-
Oh,
why-
got it, yeah.
But why does the slope need to be cleared?
Why
The pond
does-
is at the bottom, right? So you see all that those tight topographical lines?
Right, so there's a hill that's right here. In
Yeah.
order to get to the wetland is the discharge point that we want to be at, right,
Mm-hmm.
the lower point. And in order to properly size this pond in this area to take this and balance the watersheds, that's the size that it needs to be.
Oh, so part of the excavation is to clear and make the pond larger?
not larger, but what is needed to handle and mitigate the stormwater, yes.
But you've got a very steep slope there.
Yes, that's the upgradient side
Right.
of the slope. Yep.
So what's going to be there to prevent all the, soil erosion and all that, because you're taking all the trees out of it?
Sure, yeah, I mean, typically, I mean, you either have 3-to-1 slopes that are stable, and they would be stabilized with grass, or if it's a steeper slope, you would put a permanent erosion control blanket that would also protect that and keep that from having any future erosion issues.
So that's the plan for that area?
It is, yeah.
Okay.
And it's important because we did, we located, there was some discussions, about the esker in this area. You can see how the emergency access path goes around that. I mean, we're coming around, we're utilizing the existing path. You can see it lightly on here. There's an existing path right on here. That's where the existing path is. It looks like, it shows coming to here. I assume it comes to this paper street right here as well. But you can see where it comes. So we have it coming along here and then keeping it on the outside of the esker area to leave this kind of esker top area altogether. So that was the idea.
All right.
Esker. Yeah.
Just one final question.
Sure.
The testimony you provided this evening, as well as the supplemental documents that you provided to the board, are they to a reasonable degree of certainty in your expertise as a civil engineer?
Yes.
With that, we've completed our presentation, and Chief Mr. Shevlin is here in case there were any questions relative to traffic.
Okay.
Other than that, we're ready for any questions or
Ready for the,
comments.
shall we open the public hearing?
I had one question. I'm not sure who it gets addressed to. Is that private road that's going to give access to the fields, and it's also the emergency access road for EMS or DPW, that will not be a public road. So who is responsible for maintaining that road for a combination of snow removal and for deterioration over time of that surface?
Homeowners Association will be responsible for that.
Okay. Okay, anything else? Need a motion to open the public hearing.
Make a motion to reopen the public hearing.
Do I have a second?
Second.
We have a second. Those in favor?
Aye.
The public hearing is reopened at 8:12. So again, please, everyone did a very nice job of being succinct and all that. I'll be calling people up according to the sign-up sheet. One change I would like to, request is the nice word for it. Really would like not to have the big clapping. I realize that some people are very articulate, they put a lot nice, and I'm glad your enthusiasm. If you feel the need to express yourself, golf clap, right? Golf clap. And then allows us to move forward and it doesn't disrupt the meeting. Okay.
Mr. Chairman, just one thing I wanted to add. We had received from your planner,
Yep, sure.
I just wanted to make a note. We had received from your planner a approximately 27-page, I'll call it opposition letter. I believe we got it yesterday. And because of the time frame, we did respond to it. We responded to it today. So there is a document that goes comment by comment that we put forth, just so you're aware of it.
It probably has not been posted on the site.
I'm sure, but
Yeah,
it might be
right,
something that board members want to look at, or the community prior to the next meeting. I just wanted to make a note of it.
All right.
Excuse me.
Thank you, Mr. Resnick. Okay, first up, Rich Keene from the North Smithfield Heritage Association. Thank you.
Yes. Rich Keene, 7 Bamford Street, and I'm the president of the North Smithfield Heritage Association. Keene. Thank you for allowing me to speak tonight. Sorry I missed the last meeting. I missed a lot of the presentation, but it was good to get the update today, so anyway. The Heritage Association typically doesn't come out and oppose project or developments. We try to, we understand that property owners have a right to use their property to the best extent that they can. We try to work with them, with property owners and developers, and as Mr. Kelly stated, you know, I believe kind of meet each other halfway and try to resolve differences amicably. So back in 2018, it was a long time ago, we did testify and provide some proposals. I'm very happy to see that a lot of those proposals were incorporated into your current plan. So one of the main concerns was the trails, and I would say that your proposal to move some of the trails onto the roadside to get to the remainder of the trail is acceptable. So, you know, we don't have a problem with that. But one of our biggest concerns, Carl, could you put up the map, the legacy forest map? One of our biggest concerns is preservation of our natural resources in town. And can I preface that? What I should have said right from the beginning is the comprehensive plan, and I'm not going to stand here and cite it word for word, but basically, we're trying to preserve through the plan the town's character, and a lot of that character is rural in the southern part of town, and that's what we would hope to do to the best extent. If you're going to approve this plan, we would hope that you would try to preserve the town's rural character in that area. So the Rhode Island DEM in about 2020, 2021, put this map out talking about legacy forests. And as you can see, the southeastern part, which is the Nipsachuk area of our town, is right within what it was designated by the state as legacy forest. So when you talk about conservation and you talk about open space, recreation areas are open space, yes. Forests are open space. But when you're talking about conservation, every conservation area that the town owns in North Smithfield, plus the Audubon Society, it's undeveloped, it's untouched, it's preserved as a forest. And what we would like to see is as much as the existing forest that is there today be preserved as a legacy. The town recently took possession of the Gold Forest, which is just north of this development. There's 156 acres of conservation land that the town now owns. Much of that is going to be remain undisturbed. The 34 acres that the solar project is being built on is eventually in 25 or 30 years, whatever the extent of that project goes, it's going to be reforested again, and then and it's going to remain untouched for perpetuity. So this, we would ask again that we try to preserve it, the forest to the fullest extent possible. So the current plan calls for three recreation fields. Two of them are north of the on the north end of the project. That's all forest right now. We'd like to see that preserved if possible. The third one, I'm not sure what the numbers are, but the one to the very south is right on top of an esker. Now those eskers are part of our natural heritage here in town. They're some of the best eskers they've been identified as some of the best in southern New England, best examples of an esker. So we would like to see those preserved. I know there was some discussion years ago with the previous town planner that where we were trying to do the same thing, trying to maintain the integrity of those eskers. If we can do that without the recreation fields, that would be great. So that would be our ask. Now, I'm not a lawyer. I'm not going to even pretend to know anything. I know just enough to be dangerous, I suppose, like most of the things in my life. But if the planning board approves a plan with stipulations, even though some of the stipulations are not agreeable to the developer, of course, it would probably be appealed, as Mr. Kelly mentioned. But I can't imagine that trying to meet the developer halfway would open the town up to some sort of liability in court. Again, I'm not a lawyer. I don't know, but I would hope that the developers would consider trying to preserve this legacy forest, and you know, we don't even have to mention the word court. I think we could probably do that.
That'd be nice. Great.
So, so I have had a list of stipulations that I'd like you to consider, but some of them are already, I believe, incorporated. But after listening to the presentation tonight, what I'd like to do is revise that list, and I'll submit a letter to the planning board and to the developers, and
Yeah, submit it to the planner.
yeah.
It'll be reviewed, distributed to
Yeah.
whoever needs to see
Yeah.
it,
And if
and we have
there's-
plenty of time before the
And
next meeting.
we're available for discussion if
Great.
The developer would like,
Okay.
happily.
All right,
All right,
thank you.
Thank you so much. Oh, I don't know, do you have any questions?
No, thanks, Mr. Good, thank you.
Thanks.
I'm going to pause here. Carl, now the light in their eyes is bothering me too. Could we,
I'm sorry, can I, alibi?
all right,
There's one that I do need to discuss. Part of the rural character, and I think you've probably heard this from me in the past when I was sitting with you folks on the board. Curbs and sidewalks in Nipsachuk, in the Primrose area. I understand the need for sidewalks and curbs in the urban areas of town. Slatersville, Forestdale, we don't even have some when we need them in those places. However, curbs and sidewalks aren't rural. And what I would ask is that you eliminate that requirement from this project.
I think we already did. Is that correct? The
Oh,
only
you
thing-
did?
Yeah, the only thing, and it was talked about at master plan.
Oh,
years
okay.
ago. We did, but there was some discussion about some sort of soft, I believe the civil engineer said something about like a tinder path, something for people to walk on.
Yes.
And what I would suggest is looking at a permeable material, much like they did at the mosque for an entire parking lot, because that allows you to put in a nice, without people just trampling on other people's grass. It doesn't take up a
Yeah.
lot of space.
Yeah.
They have I think it's a 50-foot right-of-way with a 26-foot road, so you get 14 feet on each side. But the permeable, I think, would be a nice alternative, easy to
Yes.
maintain, keep people off the street, but at the same time, as to your point,
Right.
it's not as much like the village as it is rural.
Right, and similarly, the emergency access road, there's only a requirement in an emergency for one-way traffic going towards Leonard Estates. I would ask that road be as narrow as is absolutely needed. That's a beautiful,
Yeah, I think that's
That's a-
probably a fire department issue more than anything else, but.
well, I understand.
Yeah,
Yeah, I'm fire chief for 15 years
Yeah.
in town, so I fully understand the fire department's need. But the trucks don't need like 20 feet of roadway.
Right.
All right, so just whatever's minimally required is what I would ask.
Great. Thank you, Mr. Keene.
Thank you.
It's important to have Carl move the podium because it's very sensitive, electronically speaking. That's great. Okay. Next up, Mr. Kumar. Will you be speaking on behalf of the entire family this evening, or? I mean, it's glad to. I noticed your
Family's
wife's
at
name is
home
not on
this
the list, so
time.
I'm happy to hear you two have resolved whatever differences, and now you can present for everyone.
Yeah. Yeah. I think the family's at home, so thank you.
Okay.
All right. What's up? Okay. All right. Well, good evening. My name is Sahil Kumar. I'm a resident of 14 Leonard Drive. Last night, a team of residents, the same group that's been behind the petition from last meeting, was a 27-page written objection that was filed. I'm glad to hear that it made it to the developers. Wonderful news. Thank you. One request, can you please confirm the receipt once it makes it over to the town? Is that an option?
What, the letter?
Yeah, the
The
emails,
letter?
yeah. So we just want to make sure that it has been received. We had
Mr.
requested
Krill.
it to be confirmed. We didn't see a confirmation, but it's good to hear it made it to the applicant.
Mr. Grohl, can you confirm receipt of that?
Yes, I believe the document was sent directly to the planning board members.
That could be.
True. I think a lot
Correct.
of people were on it, yes.
Right. So it was sent directly to the planning board members. The planning department
Okay.
did receive it and forwarded it to the applicant's attorney.
Wonderful. Okay. Maybe if later you guys can clarify who can confirm, because I know there's a lot of people on emails. Just want to make sure receipt is confirmed, that's all.
Well, I made it part of the record. I actually referenced your correspondence in my response to it, so it's part of the record.
It is part of the record because we filed it. I get that part. The point I'm trying to make is we would like to know when it is accepted by the town and the board, that's all.
I'm not sure what you mean by accepted.
As in the email has been received or not? Or should we wait for these meetings to file things? If that's the protocol, happy to change that.
I believe the email was sent yesterday? Is that correct?
Correct.
Last night after 5 p.m.
Yep.
It was sent directly to the board members and to the attorney for the applicant. I'm not understanding what you're asking.
Is that whether that it has to be officially accepted or something to
Right.
make
It's
sure
part of
that
the
it's-
record. I mean, if you're saying
right.
that
Okay,
you
cool.
It is
bring
part of the
something
record.
to the meeting, it was sent yesterday.
Okay, great. Just making sure it has been received, that's all. So
Absolutely.
thank you. Wonderful.
Absolutely.
All right. Also, early today, on behalf of the environmental scientist Sarah Hayden, same Sarah Hayden who spoke over here last time on April 9th, hearing on wildlife and habitat, we also filed her separate letter on the environmental impact finding, the federal and state habitat data attached. Both of those were submitted to the planning office and the board. Also tonight, I'm also handing the board a letter from Tammy Menard. She's a resident at 20 Leonard Drive. She's a healthcare professional, and she had to be at a hospital tonight for being on call. She's raised some concerns about the traffic study, the blasting impacts, forest fragmentation, as well as the electricity utility capacity. I'm going to hand that out right now.
One to him and one to
Corolla.
Mark.
Thank you.
Okay. All right. What I'd like to do is actually relatively shorter, so just a couple of observations and asks. The first thing is, I think it's pretty clear, as I'm representing the group here, we are confused. There's no denying that, so we appreciate the patience. The agenda for tonight has the board voting on the Rankin Estates, and I know, Chair, you also mentioned that you guys will not be voting. So that confusion, if there's a way to clarify that as part of the agenda, that would be appreciated, if that can happen. Because I think the way the agenda reads right now, it reads as if the voting was happening tonight.
I think that happens on virtually all topics, but if something comes up during the course of that evening's meeting,
Yep.
we choose to continue, then we don't vote. And it's just, in this case, we were able to make that determination prior to the meeting, notified the, counsel for the developer, and everyone agreed, and so we were able to make that without seeing that, like last meeting, we could have
Yep.
voted.
Right.
Last meeting, we could have voted.
Yep.
It said the same thing on the agenda. We
Got it.
didn't, however, because there was much more material that needed to be covered and all that. So I don't believe anything is needed.
Mr. Chairman, may I?
Yep,
The
sure.
reason that the agenda says that there could be a vote is that it reserves the right of the board to vote. If we do not include it as a vote, the board is not going to be allowed to vote.
Right.
So that is,
Got it.
that is standard operating procedure,
Yeah.
so that when there's a hearing, the board is able to vote. If they choose not to vote, they continue the hearing. So each and every notice for this project and any project will include a provision for the board to vote.
Right. The key word is that we may vote. We don't
I
have
see.
to vote.
Got it. Thank you. I will share that with the team. Thank you.
Okay.
Mr. Chairman, I just wanted to add that my understanding was that some of the members of his informal association or some of the members of the community actually requested a continuance. And so
Oh,
we were amenable to it and we agreed to it.
Sure. No, I
So it
appreciate-
seems- I'm not exactly sure what it's become.
Yeah, appreciate the collaboration, but I think we all independently came to the same conclusion that there's going to be, we were going to need to continue tonight, so.
Okay, cool. Thank you. Okay, so the questions the board members raised on the April 9th hearing have not been fully answered. I know new documents have arrived, but we'll have to review those and make sure that is tight. New documents from the developers keep arriving every week. After the agenda was even published. After the agenda was published, the documents had arrived, right? We also understand the planning office has not issued a certificate of completeness on the application. So that sequence clearly where, as I said, we are confused, like what is the process?
That's false.
Okay.
No, hang on. No. He has the podium right now, please. Mr. Crow, do you want to address this? This seems like a process question, so let's
So-
start with the planner.
So a formal certificate of completeness was not issued. However, the applicant was authorized to proceed because a determination was made by the planning office that the application was ready for a hearing.
Okay. So there has not been that certificate.
It has not been. When does that get published or certified?
Mr. Carrillo?
There is no formal certification of completeness. It has been determined by the planning department that the project is ready to proceed, and it was authorized to proceed before the board.
Okay. All right. Doesn't make sense to me.
Mr. Chairman, if I could be given the opportunity, I would elaborate on that.
Please.
Let's do that after, when Mr. Kumar is finished his, okay? Thank you.
Thank you, Chair. All right. So I want to say this carefully because I don't want this to land as a shot at anyone in this room personally. So please don't take it personally. Something about this whole process, which we've all talked about at the start of this meeting as well, is complicated. But at the same time, it also seems a bit absurd. The project has been in front of the town for over 40 years, I heard, right?
20
years.
22, something like that, yeah.
Okay, cool. The master plan was approved a while back. There have been multiple extensions. There have been multiple revisions. There's been new filings on top of new filings. And just in the week since the April 9th hearing alone, new documents from the developer have arrived in wave after wave. And each wave shows more gaps than the last one. We don't think this is a reflection of the experts and a bulletproof team, rather probably 10,000 miles from it. If we take a step back from the specific filings and the specific inconsistencies for a minute, and just look at the pattern. Every time residents raise something, the applicants address it, that one thing, and then new things surface, and the residents have to raise the questions next time around. The applicant is not holistically reviewing their own application. They are reacting narrowly to what gets raised in front of the board. In any professional setting where serious applications are reviewed seriously, engineering, legal, financial, others, a filing that needed that much external correction over this many rounds would have been pulled back a long time ago.
I understand, Mr. Kelly. Please let me address that. Please let me address that. And I agree with you. This is. So I'll let you finish, but then I'm going to take the first pass at addressing your comment.
I appreciate that. Thank you. Okay, so the question's actually in front of the board. At some point, you have to decide whether what you're looking at is a normal back and forth on a serious application, or is it something else? I'm going to pause here.
Okay.
Yeah,
So
please.
with that, I'll say, in agreement with Mr. Kelly, while this project is more complex and has a more complex history to it, it is following normal process.
Got it.
It is not for them to question their own design. It's our job. I don't know what your background is. I'm a computer software engineer,
Okay.
software architect. We hold design reviews. The whole job of the design review, the engineer presents their design, our job is to shoot holes in it. They should have already found holes. They should have already shot their own holes in it. So now it's up to us to do it to make sure the project comes out right. And that is all we're doing. So you're right. And again, everyone's been very collaborative, and we've provided these continuations of the meeting because new things get raised. And yes, when new things get raised, and some of them are substantial, then it's going to answer a bunch of questions, but it's going to raise some new ones, questions or concerns, in which case we go through the round again. That's completely normal. That's completely normal to me in
Okay.
the engineering process. That's how things are done.
So I understand iterations, and I understand the part that
Let me add one more
Yeah,
thing.
go ahead.
When you talk about the master plan,
Yeah.
this is actually the second time this developer has gotten master plan approval. They first got master plan approval for a non-conservation development many years ago. And now they've gotten master plan approval. They came back years later with a completely different approach, the conservation development, and they got master plan that. So we're actually on our second one, so that, those first number of years were all based on that. And then we started essentially a new process over with the conservation plan.
Got it.
Okay?
Okay, thank you. That's helpful. Okay, so moving on with a couple of other items here I want to raise. The state letter from 2022 saying the archaeological survey, which we heard at length about, was wrong. Residents surfaced this at the April 9th hearing. 5 days later, the planning office admitted in writing that the town file had the wrong version of the document. The corrected version finally appeared on the town's record 3 weeks later, and that's almost 4 years after the state had ordered the correction. I can email you the thing. The 4-bedroom versus 3-bedroom contradiction between the plan set and the fiscal study that residents pointed out, and a new engineering memo arrived this month trying to defend the inconsistencies. The 400,000 cubic yards of dirt and rock that have to be hauled, off the site, admitted in a letter from the developer's lawyer this week after residents kept pressing on where the cut material was going. And in everything the developer has filed, there is still nothing on how that volume of bedrock comes out of the ground, whether blasting is required, what pre- and post-blast protections will be in place for the neighboring private wells, foundations, and pools, and who pays for the damage, if any, occurs. The developer's own traffic engineer told the board at the April 9th hearing that no residents would use Brookside Drive. Is that correct?
Yes,
Because-
correct.
Okay.
Because it's going to be gated by the emergency access only.
Perfect. We think that contradicts the traffic study underneath the entire application. The study routes about a quarter of the subdivision trips through Brookside. The developer has walked away from their own engineering, and the study has not been redone. On top of that, the traffic study was conducted in August of 2024, when North Smithfield schools are out of session. Many residents are on vacation, and commuter patterns are distorted compared to the rest of the year. The safe access finding the board is being asked. The safe access finding the board is being asked to make cannot rest on the traffic count taken at the least representative time of the year. At what point does the board want to look at the record here? Sorry, I'm just paraphrasing since we already talked about a few things here. Okay, I think this we already covered. I don't want to be repetitive. Please bear with me.
Thank you.
All right, and then before I close, there's a specific request. I'd like to request the board to maybe walk the property. Not more documents, actually go on the land itself. This is not a novel request for this board. This board has walked properties back in 2020, as well as 2022. There are things on the sites, hundreds of pages of engineering report are just not going to capture it.
We did walk, I personally was part of a walk on the property.
When was that?
18 maybe?
Okay, so that was
pre-COVID. But it was a meeting, public was invited because we had at least 3 planning board members, we had the developer, and we walked a section of it. We did not walk the whole thing as good as that would have been for all of our health. It was, but we got to see some of the steepest areas and wetlands and all that, so.
No, it's a big property. I think that date is interesting. We would still encourage you guys to go walk it again because of the buffer violation that happened when the 17 acres of forest was cut down.
If there's a buffer violation, is that more for the building inspector?
It's a DEM issue.
Okay.
Being addressed, the restoration plan has been submitted, we're waiting for approval.
Okay, so we have a plan waiting for approval.
The study was not made, wasn't said it was wrong. They asked for an update, which has been done.
Okay, thank you.
It was done years ago.
Okay,
Just do
thank
pumps out.
thank
We're gonna get
you.
the whole story out.
Well,
Excellent. Thank you.
As long as we can keep it, let's keep it brief.
Yeah, no, thank you. I am sorry. I'm just reading through this really fast to actually.
We'd like to know who he represents before it's done, if you don't mind, because he indicated he represents a bunch of people. He should indicate.
There was a group.
There's a petition that was filed last meeting. Did you get a copy of that?
Yes.
Okay, wonderful. You have
Who
it.
do you represent?
Does that document include the list of people that
Yes,
it
it
represents?
does.
Okay, so you should have that.
We'd like to hear all the people that he represents, because he indicated that he's here in the capacity of representing other people.
What he says, and this occurred last meeting as well. They got together and they had they designated one person as their spokesperson, which, quite frankly, is makes a lot more sense than having each person pick up one element to talk about or risk repeating themselves over and over again. If it's appropriate to have your group sort of sign off that,
Sure.
they agree with everything you said, that you properly represented them, that's reasonable. I don't think we need to have, 29 people here, each one telling us something.
Thank you.
Would that be acceptable if you provide something that signs off? Okay.
Fair.
Let's
And
do
what
that.
purpose would that actually
He just wants
serve?
It's unorthodox for someone that's not a lawyer to represent other people in a public.
We've had this before where people come up, they speak on behalf of residents. They're not doing it in a legal capacity. They've just gotten together as neighborhood people do, and gotten their thoughts together and they decide to have one person who's fairly articulate, whatever, represent them, we don't have any problem with it. We don't take it as a legal representation, too.
So not unorthodox, totally acceptable.
It is
Thank
to
you.
us, yes, absolutely.
Okay, great. All right. Sorry. So the last thing I have is really for the board, a request, a procedural request. The group is actually thinking about doing a baseline well testing for private wells along their properties. A group of residents is, sorry, I'm just paraphrasing this again. Okay, so yes, so the protocol that we're looking to follow tracks the State Department of Health owns recommended panel. We're asking the board to acknowledge the methodology. We'll be sending an email about this so that the final results of the case are made on record of the town itself. It's no different than people collecting their own data, but we believe it would probably help in keeping all of us in check. Because if there is no issues, that is also going to get proved with the test itself, and the team plans to run these tests on an annual basis going forward.
Okay.
Chairman, that will require expert testimony. We're not
Y-
going
yeah,
to
that-
testify about wells and groundwater.
You would allow an expert, though?
They should have an expert.
Yes, I would say if you want to present the results, then yes, you would need to have an expert to do that. I think it's fine if you want to test your own water. I mean, it's your water, you test it. You know.
Sure. But it's tested by the State Department's recommended methodology.
But
There
by,
is-
it's who's conducting the test and whether or not they are certified, let's say,
Sure.
to conduct those tests properly.
So-
And they would need, so that we would need to see someone like, but for you to be able to sort of put these on record, it needs to have professional certification backing.
Absolutely. So I want to clarify that, though, because our understanding is it is something that we will test in our homes. Either a human is going to come out or people will ship the tests over following the protocols. Results will come back, and it usually gets emailed over. I don't think a human is going to come out and represent and say, yes, I ran this test and these are the results. I think that's
Mr.
the...
Curlo, we've had a number of sites where water testing was done. What do you recommend for this?
Well, I think what the gentleman is suggesting is they're going to do their own testing, send it to a lab, they will get the results, and they're reserving their right to come here and present whatever result they have, and you can apply to that whatever weight you apply.
With or without an expert?
You don't necessarily need an expert for him to bring in a test result. It's whatever weight you apply to that.
True.
Right.
But
It's a certified result from a
But it will have less weight. than
Okay,
like,
great. Thank you.
Expert representation.
That's all I have.
Don't you understand? And that's fine.
The protocols are very difficult to comply with.
Mm-hmm.
And the
Yeah.
tester doesn't know if they have been compliant.
Yeah, I also, again, in our experience, we have had people where a person actually goes to
Yes.
the sites to do it, and especially say you're doing, 15 houses on Leonard. I mean, they drive up there one day and they just hit every house. It's not like
Great.
it's some great burden on them to do this.
Great. We'll do
So
that.
I would look into something like that makes it
Yeah.
a little better than, I mailed some water out of my faucet, that kind of thing,
Got it.
Just
Thank
something
you.
to consider.
Absolutely. Appreciate it. Thank you.
All set?
Yeah, that's it.
Thank you, Mr. Clark.
I ask him a question, how far
Well, you-
away from the nearest house in Leonard Drive is are the new houses going to be built? What's the closest house in that subdivision from the nearest house on Leonard Drive?
Looks like it's that
I-
pale blue one.
What's the distance, sir?
I'm gonna go.
I actually don't know the
I
distance.
didn't think so, it's 1,200 feet.
Okay. And what's the point of that?
The point of that is your suggestion that the wells will be affected by a home that has a well 1,200 feet away is scientifically ridiculous.
Mr. Guy, I think there's also just concern about the rock removal, and we haven't even heard about blasting or anything like that until tonight. But anyway, I think that's the concern, but I think we'll leave it at that for now as a concern, and it needs to be supported through better evidence. So,
Yeah.
But we'll-
If other property owners around the development want to run a test, that is their right.
You can do whatever you want, but
Correct. Yeah.
So you can submit whatever you want.
All right,
and move to strike it.
Let's,
Absolutely.
Folks,
Yeah, so
folks,
let's not-
can I jump in for a minute?
absolutely.
Mr. Kelly, Mr. Resnick, I appreciate the back and forth. This group has been quiet during the entirety of your presentations. This right now is the public hearing. I would like to just leave it be.
Right.
Let the public speak. Take your notes. You can address them at the end, once we wrap up the public hearing. But this back and forth right now is really frustrating and aggravating.
It
I
is.
get it that you're aggravated, that there's some statements that are being made that are untrue. I get that. You'll have your time to address them, but the back and forth is just wasting time, and I don't like to waste time. I want to hear from the public. This is their time. You've had your time now, so let's leave it at that and move forward.
Okay.
Thank
With
you.
that, Mr. Kumar.
Thanks.
And next up is Mr. Hebert.
Hi, my name is Alfred Hebert. I live at 2 Francis Farm Road in North Smithfield. I lived in North Smithfield since 1975, and I've lived in Rankin Estates since 1987. I served on the North Smithfield Zoning Board in the past. I've also served on the Charter Revision Commission. I've served on the 3 Building Needs Committees. I've served on the Tax Board. So I've been very involved over the years. My time on zoning taught me an awful lot. And I as well as other members, we were sued quite a few times. We almost always won because we did our due diligence. And the fact of the matter is, we walked the area, made our own observations, listened to the expert witnesses. Most importantly, we always follow the ordinance, always follow the rules and the regs. We never deviated. We always were very concerned with precedent, never wanted to set precedent if there was any way to avoid it. And in this particular development, it's the first time we've dealt with this type. Precedent is going to be set here. So it's vitally important that, again, we dot every I, we cross every T, and that we utilize the solicitor to the fullest so that we can make the proper decisions. I have faith in the fact that you're going to do that. I have faith in the fact that you're going to make the correct decision based upon all the evidence. My 40 years living where I do, I've walked this area so many times. I'm intimately familiar with it. It's really a living area. And a lot of it's because of the beavers. You walk through there today, you're going to find a pond, you're going to find wetlands. 2 years from now, it's going to move. That's just the way it is. It's a beautiful area. It's a natural habitat, supports all kinds of wildlife. It's a truly unique and beautiful area with everything that the town has sought to preserve for years. And with that in mind, I'd call your attention to the Town Comprehensive Plan, Section G 3.2.2, Historic Districts and Areas. Under other historic areas, you have, under other historic areas worthy of protection that are included all the way back to the 1980 report, we have Nipsachuk Natural and Historic Area, located in the extreme southwestern corner of North Smithfield, south of Lake Bel Air, and west of Nipsachuk Hill. This area was historic importance during the King Philip War in the late 1600s, but is still geologic. It is still of geologic interest due to its swamp, irregular cane and kettle topography, and eskers. The comprehensive plan mentions this area as being worthy of protection. Now, I'm not saying that we shouldn't have this development. What I'm saying is that the area itself, especially this wetland area, is worthy of protection. This is where the brook is. This is where the water comes out of Nipsachuk Swamp into Nipsachuk Pond, goes down the brook, goes right into, you know, the Lake Bel Air area. I have friends that live down on Brookside, and the first time I went there, I was amazed at how the stream wasn't even a foot below ground level. It's basically running at ground level right through their property. And they all have wells. So preserving this water, to me, is vitally important. Preserving the habitat for the wildlife is important. Now, the developer has stated that the open space would be accessible to the residents only, and that's a good selling point. Rankin Estates residents are going to have to pay taxes on that property. They're going to have to obtain and pay insurance on that property. And yet, if the open space were deeded back to the town, the developer and later the residents of Rankin Estates would have free access just like everybody else. No one pays for something that they can have for free. Would you? Additionally, once children of Rankin Estates go to school and play sports here in town, like all the other kids, soccer, basketball, football, Little League, they join teams, they make friends, they play after school with children of the other 3 surrounding developments in Brookside Drive, just like they do today. And all those kids are going to, you know, they're going to play. They're going to play together. So now the residents of Rankin Estate are paying taxes and insurance on land that's not even exclusively theirs anymore. Now add to that the retention ponds are within the open space. Whoever is in charge of the open space must maintain those ponds or force the town to do so and then be billed by the town. So again, more fees for the HOA. We just learned this evening that the emergency road is not going to be a town road. The HOA is going to have to maintain that, which means they're going to have to plow it. They're going to have to resurface it if it needs it. I think what I'm asking the developer, I don't believe that it's financially necessary to have this open space only for the residents of Rankin Estates. And as for the fields, as was stated last time, they're not going to be open to the public. They're not going to be, aren't going to be games held there. It's for kids to go down and kick a ball or throw a frisbee. Excuse me. Dry mouth. Now we have fields all over town. All the kids in the surrounding developments go right down here to the turf. They go down to the middle school. It's a couple of miles down. Just go down Route 7, bang a left on Greenville Road, and you're there. So who's going to use this? It's going to be, I assume, the little kids in the development. But little kids play in their yards, or they play in their friends' yards. They don't go halfway or all the way across a development and cross a brook to kick a ball or throw a frisbee. Again, I don't see why this is advantageous to the developer. How are they going to get more money for these lots? Because they have a little field over there that kids can throw a frisbee? I would love to see this open space, just this section here. I think the open space, as indicated in the other areas, I think that's great. Kids can go play there. You can put a swing set in there, or they can kick a ball in those areas. Donate this open space back to the town. It should be in the hands of a governmental authority with regulatory controls. That way, we can be more assured of the brook being protected, the quality of water being protected. Again, keep in mind, not only does this brook go down to Lake Bel Air, it goes down to Tarkland Pond. It ends up in the aquifer in Slatersville. It's pristine water. Why jeopardize it? As Chief Keene said earlier, from the Historical Society's point of view, we should be preserving as much as we possibly can. I've also put together a list of stipulations for your consideration. Some of them I think are really important. Others, it's when I was on zoning, I did almost all of these. I'm going to give you a copy, but I'm just going to very quickly read a few.
Yeah, because what I'd really like you to do is submit them to the planning office. Because that'll give us, we're going to need time to review them anyway.
Absolutely.
And also, we have about 30 minutes left for the public hearing before we're going to close that down so that we can have any closing conversations and all that kind of stuff.
All
So
right.
I'm not trying to cut you off. They'll get much better attention, as they will in the upcoming weeks, but I don't think we'll do much hearing a few of them right now.
All right, I just want to read a couple, because one of the things I want to do is I'd like these placed on the deeds. And the reason for that is you can have a homeowners association, you can have all kinds of rules, but if certain stipulations are placed on the individual property deeds, they're there forever. So very high level, just no hunting, no trapping in the open space, no interference in any way with wildlife, resident or transitory, no destruction or damage to the beaver dams, no dumping of material. That includes construction waste, no yard waste, or homeowner waste of any kind in the open space. No motor vehicles in the wetlands. This is the type of thing that I think we need to consider and actually have placed on the deeds. I also have stipulations with regard to the development and how it operates. There's only one I want to point out, and again, we did this on zoning. There's an awful lot of traffic on Route 7 at certain times of the day. When school buses are transiting that area, I don't believe there should be any trucks entering or leaving the development. The school department can inform the building and zoning inspector, who can inform the developer when the buses are transient. All of the children from Lower Matity Road, from Log Road, from the developments up there, the 3 developments up there, are all taking buses directly down Route 7 to the schools. All the schools are located in that one area. And with that, I'm done.
All right. Thank you, Mr. Hebert. Kelly Wrightson?
Actually, with consideration of time, I'm gonna pass.
Sure. Save it for next. Oh, okay. Mike Mayo?
Yeah, Mike Mayo, M-E-O, 8 Christina Way. What's that? Good evening. As I just stated, Mike Mayo at 8 Christina Way. I have a few additional comments to make about the fields. To be clear, the question of whether these fields would be approved as part of this development was not resolved at the master plan approval stage, as has been suggested in past hearings. Rather, the very first condition of the March 6, 2019 decision of approval deferred that issue to this preliminary review stage. The town planner at the time and several members of this board were highly skeptical of whether these fields were consistent with the interests of this community and with the overall plan for this conservation development. And I do not believe we've seen anything in the years since that should change this board's mind. When you look at the layout of this development, the open space portion along its western border provides a much-needed buffer between this proposed 126-lot construction site and the neighborhoods to the west and to the north. And right in the middle of that open space, the developer wants to construct not 1, not 2, but 3 large fields, albeit smaller than on their last plan, plus a parking lot, really for no discernible purpose. Now, the developer argues the fields are for the future recreational use of the residents of this new development. Even if that were the case, why would the construction of these fields need to be included at the very beginning of this proposed 10-phase construction project when there are not yet any new there's not yet any new neighborhood, there are not yet any new homes in that neighborhood, and there are not yet any new residents in those homes to utilize these fields. Now, I would imagine the developer will say that these fields are adjacent to the emergency road that needs to be constructed, and so it's more efficient to build them right up front. Well, I would say to that just because it may be less expensive to the developer doesn't mean that that's what's in the best interest of the town. Now, I ask this board to consider, why would a developer want to construct such large open fields and a parking lot in the middle of the open space of a conservation development before anyone is living in that development to use them? And in particular, why has this developer been so persistent over the years pursuing these fields? Really, oftentimes I feel like this whole issue is about the fields. I mean, when you look at this development, it's a huge development, and we're focusing a lot of time just on these 3 fields in the open space. These questions really get to the heart of why the community is so concerned about this development. Attorney Kelly's correct. The community is concerned about this project becoming an excavation and mining operation. And the developer does not really seem to be denying that's exactly what it plans to do. Rather, it's arguing that the code permits it to excavate the property, and the code says it may build these fields, and therefore this board must approve them. I believe that's overstating things. I believe this board does have some discretion on these points. Otherwise, why have a public hearing, and why would you need a vote at all? And in exercising that discretion, please consider that the layout and the phasing of this plan, and of the fields in particular, does suggest that the developer may want to dig into the back end of this property where the most valuable gravel exists as soon as possible, blast it, mine it, pull out all the gravel, and leave the town with a carved up, cratered mess with vertical cuts into this land of up to 30 or even 40 feet on what used to be pristine, natural, and historic land that is a critical part of this town's rural character and why so many of us chose to live here in the first place. That use is not consistent with the town's comprehensive community plan. It does not maintain the rural character of this community, and it does not protect the natural systems of this land. So I urge the board to reject the inclusion of these fields and parking lot as part of any preliminary plan approval, and instead require this open space to remain just that, open in its natural state. Thank you.
Thank you, Mr. Mayo. Caitlin Gonzalez?
Yes, Caitlin, K-A-I-T-L-I-N, Gonzalez, G-O-N-S-A-L-E-S. Hi.
Hi.
My name's Caitlin Gonzalez. I live at 420 Douglas Pike, so I do live near where the entrance would be for Rankin Estates. I'm here tonight as a parent with concerns regarding the bus routes, as the gentleman prior to me had mentioned. Right now, I stand outside on Douglas Pike twice a day and watch the bus try to drop off my son, in which cars are constantly flying through. My large concern is the amount of cars that will be coming in and out of this development. And if you travel Douglas Pike, you will notice there's actually no speed limit sign once you cross from Smithfield into North Smithfield. So cars tend to go much faster than 40 miles an hour. If we are adding, say, 240 garages so that you got 240 more cars coming in and out of this development over 7 to 8 years, more traffic coming in and out, more cars to not stop for these buses. I have skid marks in front of my house from cars flying up the hill trying to stop for the bus. For other homes around me, my concern is for kids' safety. My concern is you're gonna have 75 more students coming onto the bus. Are they gonna be stopping on Route 7, the bus? So then you have traffic backing up for a couple minutes while you're loading all these kids up. Again, having cars flying over the hill. I am just a concerned parent who would like to have some consideration about the effects of kids in the buses on Route 7.
Okay,
Thank you for your time.
thank you. Rob Edelman? Did I get that correct? Sure did. Great.
Robert Edelman, R-O-B-E-R-T. Edelman. I'm at 114 Pomona Street. I don't live in Pomona, Pomona. So I don't live near this. I came down here to support a friend. And the reason being is this is one of those things where, it doesn't matter to you until it affects you. I had no intention of talking tonight until I heard some of the things that were said. And let's start off with some observations. I mean, first and foremost, the attorney started and, the ask was, let's have a fair hearing, open dialogue, and it started with the threat of a lawsuit to my town. I think one of those speakers spoke well, said, do your due diligence here, and that protects you. So that threat should be baseless. Then they discredited residential input, that we're not experts, that some of the things we say aren't going to matter, that the relationships you have with the town and the people shouldn't matter. I disagree. Your relationship with your residents you need to look out for our well-being. You need to, there's a town charter. You should read the charter. It matters. Then, listen to what was presented. Some nice dancing on semantics, some creative and aspirational math. I think, Mr. Pilardi, you did a fantastic job pointing out some significant discrepancies. That matters. And I took some notes today. I would say, all the back and forth about population density and what that means, and that coming up a couple times to restate what that means. But the reality is that was presented originally in a context to mislead. So, I mean, it's hard to sit here and believe everything that was said. So, what I would say is, yeah, we're not experts. But, as I'm sitting here and Mr. Kelly, I think his name is, we're talking about how much material is going to be moved. 350,000 yards. Well, I'm not an expert. The AIA says, the impact of removing 350,000 yards of material, habitat loss. It can lead to significant habitat destruction, local wildlife, plant species, fragmentation. Landfill waste. So, it's contributing to landfill overload, exacerbation, existing waste crisis, producing toxic leachate, methane, all that fun stuff. Dust and air quality. So, sure, you're removing 350,000 yards of material, but you're moving 900,000 yards of material. So, air quality, dust, water bodies, all that fun stuff. You're talking about 8 years of exposing residents to that. Right. That matters. Soil degradation, we can go through all that. You have experts. I'm not an expert, but, in the hours I'm here, this needs a little more insight.
Okay.
So I have to say.
All right. Thank you, Mr. Edelman. Peter Godon? Did I get that right?
Oh, it's Godin.
Godin, okay, thank you.
Godon, 170 Log Road. Excuse me, sir. Could you put the second map up here that showed the fields? Yeah. Slide it down a bit if you can.
I can't. It's just.
All right, okay. Correct me if I'm wrong. There are no plans right now for the town to sell or donate land to the development. Is that true?
No.
Okay, very good.
The only thing that's been suggested is the opposite.
Okay, very
Yeah, I
good.
mean,
I'm just.
Town doesn't usually do that.
Right. I'm just laying the groundwork. That's Brookside Drive.
Mm-hmm.
That's not on their property. That's the town property. That little hook going off where the road is going to go, I believe the proper name of that road there is Overhill Road. If you look at the GIS map on the town, all those lots around it go up to those roads. They don't include those roads. The gate is going to be put further up on Brookside Drive. So we're giving them the opportunity to use the other roads, and are we not going to be able to be on that?
So, one point of clarification. The gate needs to be on your property, correct?
Well, it's not.
The
That's
gate? No? Oh, okay, so the gate is on Brookside Drive,
Yeah.
but not on any,
Yeah.
in the public right of way? Sorry.
In the public right of way on Brookside Drive.
Okay,
Right. So we as a town own that, all that down, further down, and then also that hook that the path is gonna be on. If that gate is further up to the north, almost off the screen, that's basically giving them all that land. Now, I know on the roads in there, it's gonna be town maintained, that means we could be driving on it. Is the path or the road, whatever they wanna call it, that's gonna go down to their fields, that's gonna go, across from lot 70, between 72 and 73. Is that open to the town?
no, they've stated that that's
It's
for.
not open to the town,
They've
so
stated
it's
that's
gonna
for
be their
residents
little
only.
domain. That means that the extension for Brookside Drive is gonna be their domain, we can't go on there. And Overhill Road,
So you're talking about the small piece
yeah, that little hook
before
over there,
the blue
if you
hook?
look on the GIS maps on town, that's Overhill Drive.
Gotcha.
I believe I have the name
Okay.
correctly, it's something like that.
And I believe that's being incorporated into the emergency road, is that correct, Mr. Privy?
They're
Thank you.
using that. So,
Wait a minute, excuse me, is that correct?
Yes, it is.
Okay,
so how do you give one group of residents sole possession of town property?
Mr. Solicitor, is this a valid point? Because that area, that sliver of blue, that's outlined in blue, is not part of the property.
Right. You
And
look
yet
at
it
the GIS
contains-
maps,
And yet it contains a small piece of Brookside Drive and the Overhill Road, I believe you called it?
Overhill Road.
Overhill Road. And in giving them private access only, there seems to be a valid point being made.
Yeah, we'll try to look into that. And
Okay.
have that for the next meeting, first week.
Like I said, you look at the GIS maps, you click on all those lots, it shows you the border, and they all border Brookside Drive extension, that's not, that you can
Yep.
see on there.
I-
And also that hook, which is, it goes up to a dead end. If anything,
Yep.
if you don't want people leaving there and going down Brookside Drive, I totally understand that. But if that's gonna be their little sole possession, then that road going between 72 and 73 going down there has to be public road for everybody else. And then
Fair
put signs at the end of, Overhill Road, no trespassing, blah, blah,
Sure.
blah.
Okay.
But you can't give one group of citizens sole possession of town property.
Your point's made,
Valid
thank you.
point.
There's one more ahead of you there, Dr. Benoit, there's one more ahead of you.
I just
Oh.
want to make a comment about this ownership
Okay,
from historical records.
could you,
I need you to
I-
come up and state your name for the record, please.
yeah,
Lucian Benoit, 28 Ridge Hill Road. Historical records will probably show that Narragansett Improvement has owned all the roads around Lake Bel Air. I do not believe they've ever been deeded to the town. That would be something that would have to be researched perhaps, but that's my understanding from my living there my whole life.
okay.
Thank you.
Thank you, Dr. Benoit. All right. Frank Ribezzo?
Yes, that's right.
Thank you. If he's quick, Kelly, you're still going to have a chance to get up there tonight.
R-I-B-E-Z-Z-O. Good evening, everybody. My name is Frank Ribezzo. I'm a resident of North Smithfield. I reside at 525 Douglas Pike. I've been living in the town for about 21 years. Ironically enough, my property was built in 2005, right around the time this development was proposed. My driveway exits immediately adjacent to the Route 7 104 intersection. In 21 years, I've witnessed 3-4 dozen serious accidents at that intersection. There's a memorial right down the street now from somebody who passed away recently there. I've seen people taken away in ambulances. One of the primary drivers, in my opinion, having pulled out onto that road for 21 years, is that the southbound lane of Route 7 comes down around a slight turn down over the crest of a hill. And as one of the previous residents testified, cars travel fast. I've seen cars 60, 70 miles an hour. They're on you fast. There's very little reaction time. So this proposal wants to put 126 homes immediately north of that intersection, 250 cars, 300 some odd 350 residents or so. They're all going to be leaving for work around the same time. They're all going to be coming home around the same time. There's going to be a significant increase in traffic. That's a 3% increase in the town's population, if my math is correct. So my question is, what traffic considerations have been made for this particular intersection and the entrance? And there is only one entrance and exit to this development, as I understand it. So what traffic control considerations, what traffic control devices will be applied to deal with the additional traffic? Will there be a light? Will there be traffic cameras? Will there be additional police presence there? Will there be speed bumps? So I haven't heard anything about any considerations for that. And as I've said, I've personally witnessed 3, 4, 5 dozen accidents in that intersection over 21 years, and there's many dozens that I haven't witnessed. So that's my major concern right now. And I just want to note that, as I said earlier, I was building around 2005. There was a proposal to develop this property just prior to that. I think it was about 95 houses, which was rejected, and this one's about 30 houses more. So after the rejection, they increased the size by 30. I don't know if there's been any consideration for reducing the number of houses.
To put that in perspective, if it was done before 2005, then it probably was not a conservation development. And the conservation development that this developer put together first has considerably more houses, I believe. Is that true? Like 200 something? I'm not sure. It's quite a large number. So the 90 would actually compare to that.
I'm not anti-development by any stretch of the imagination. My cousin's developing property at the Pines right around the corner. I'm just concerned about the traffic, and I'm concerned about safety.
I know the intersection well, and you're right, and it's not just limited to the southbound lane. The northbound lane has that little hill, and you don't see people coming. Yep.
It's a dangerous area. So is there any, I think there was indications that there was a traffic expert here tonight. Is he still here?
Yep. Yes. We'll let him address that when we close the public hearing, because we'll have about 25 minutes. Okay?
Thank you.
Thank you. Next up would be Kelly Wrightson. You sure? Okay. You may. No. Yeah, just introduce yourself and your address.
I'm Deborah Barrett. I live at 801 Douglas Pike. B-A-R-R-E-T-T. And I've been in the town for 45, 46 years. I'm on 801 Douglas. I am where you are. I am on that bad curve down at the bottom of where 104, my house is in front of 5, 7, and 104. You cannot imagine the traffic that is on Douglas Pike. I have been watching it for 45 years. I'm a critical care nurse in the ER, 50 years, I just retired. Okay?
Ms. Barrett, could you just get a little closer to the microphone?
Sorry.
Thank you.
You can't, there's more than what you're saying about depths. I have scraped gray matter off of the pavement. My daughter, who's a retired police officer now, that she's in Barville, she witnessed that recent fatal. I had 2 kids in front of my house that I didn't even know that the car was over the crest of that. I pulled out of my driveway that morning, and there was 2 dead people right across from my house. The amount of traffic on Douglas Pike is lethal. I cannot pull out of my driveway. It's one car after another. Initially, yes, the traffic was like maybe 7 to 8:30 in the morning, till then around 4 to 5, 6 o'clock. We live in a bedroom town. We all sleep here. None of us work here. We live in North Smithfield for peace, tranquility. I'm a senior citizen. I just turned 70 in January. I cultivated this town to where it is. I have volunteered. mentor for the Children's Crusade. I've done it all. Douglas Pike cannot take any more traffic. And is the town going to add more police, EMS, fire and rescue to promote the amount and volume that's going to be added to this town? I get you with the buses. Oh, there's new families coming and going, coming and going. You this morning, now that I'm retired, I can watch all this traffic. It's ugly. And it's a state road, so maybe, and I don't mean to be nasty, it's a state road. So maybe, I don't know if the town officials even care about Douglas Pike, because the state takes care of that road. It's insane. I can't, and I know people probably want to hear this, but somebody that lives on Douglas, there's going to be another 50 houses going up off of Douglas Pike between Rankin and my house. I just found this out when I was at yoga the other day. And the land has been 100 acres, the land sold, and they're gonna put like another 50 houses besides this whole, whatever, this is insane. Well, all I'm saying is, safety, to me, I'm a lifesaver. I mean, my whole life was critical care nursing, 50 years. That's my passion. And I worry about safety on that road because it's going to get ugly. And is anybody here from Material Sand and Stone, by the way? Has anybody watched their trucks? One after another after another. They have an inlet past my house on 7 to the left. They're coming out on Greenville Road. Those brakes are ridiculous because they're coming down that steep hill, and now they're in a valley. That's where I live, and now they're ramping to go quick because not only are they going down that steep hill, they're going to go around the corner, and now they're trying to go up the other side of the hill. And I hear them both ways. There's going to be people going to be killed on that road. And I don't care about the developers and their money and all this other stuff that they put all billions and billions. To me, I can't put a price tag on a life. I can't. I never did. A life is a life. And if it's more important that money, it's disgusting. My neighbor, Ricky, just moved because he said he couldn't stand the road anymore. Ricky built that house with his own 2 hands. A great guy. He left the town. You want people leaving the town? Good people who cultivated what the town is today. Okay? We worked for decades to make the town what it is today so that people want to have that peace and tranquility in their lives. And North Smithfield is a great town, and we need to keep it that way. If we allow any of this to go on, we're just destroying everything that we worked for decades. I'm sorry I was late tonight. I had another meeting, but I'm really sorry that I came in on this. I don't know what else was said before I got here.
It's okay.
Okay? But
thank you, Ms. Barrett.
there's a lot to be considered.
Mm-hmm. Thank you,
everybody.
Kelly, we're going to give you one shot. You want to close it out? There will be, she's going to be last. But we've got the next meeting coming up, so.
Do you know? Yeah, why? So I don't have any loopholes or, regulations or.
Kelly, could you just state your name and your address, please?
Kelly Reitzer, and I'm at 2 Leonard. 2 Leonard.
Thank you.
I moved to 2 Leonard Drive probably now just about 3 years ago. And I moved there for privacy and quiet and peacefulness. And that sounds like that will be coming to an end if this moves forward. There's already a great deal of wildlife that are already roaming our neighborhoods. So once we get rid of their neighborhood, where they I just don't know where they're supposed to go. I guess they'll just be more roadkill. But yes, to the last speaker's point, I did not move to North Smithfield for this. And I just don't see how taking my dog for a walk in the mornings or in the evenings will be doable anymore. That's all I have to say. Thank you for hearing me.
Thank you, Ms. Reitzer. So with that, we're going to look for a motion to close up the public hearing, to continue it.
Yeah, we're going to continue.
To continue.
Yeah. So, are we planning to have the next meeting at the middle school, or are we going to maintain it here?
I'm not sure it would be necessary to move to the middle school.
Okay.
If we do move to the middle school, what I had mentioned earlier is we would have to renotice. I don't see that there's, the room capacity is 82. We have 24 people here that wanted to speak on behalf of the project. So it's the board's prerogative naturally, but.
Okay. No, I just wanted to make sure that we're, doing what we need to do. So then in that instance, I believe we stated that we're going to continue I'm going to make a motion to continue the public hearing to a date certain of June 25th.
Second.
One
Yeah,
point.
it works for me. So
the
June
25th
25th is an option, or July 9th, I think the chairman mentioned, but either one is.
Okay, so
is-
we can put that in writing, the 25th.
That's correct. I think
Okay.
it's important that everybody is available, that we need all members available all the
Correct.
time.
Right. I don't see any reason
So
why.
either one of
that
those
be-
dates, a problem with any of the members.
Not for me.
I'm looking at you, Mr. Menard.
I don't plan to go anywhere.
He's going to stay here
He
until
doesn't
then.
plan.
Yeah. Okay, so we have a motion to continue the public hearing to a date certain of June 25th. Those in favor?
Aye.
Aye.
Opposed? None? Public hearing is continued until June 25th. And with that, now we have about 28 minutes to kind of summarize what we've heard, answer a few of the questions. I will ask that we not stretch out the answers or comments any further. I know there was some of this raised some emotion. Let's try to keep that out of it. But there are a lot of questions to be answered, and some of them are just, I think some are simple factual questions that could be put to rest right now too. But I know Mr. Privy's been making copious notes there. So would he be next up then to address that, or do you want to start?
You had mentioned the last two speakers had raised traffic concerns.
Yes.
And Mr. Shevlin is here, so
Oh,
I think
good
it
point.
makes sense to have Mr. Shevlin address those. And then if we have an
Okay.
additional time, certainly Mr. Privy can go.
Absolutely. Good. Okay.
And Mr. Chair, I would just. I would just remind the board, we already swore Mr.
Yes.
Shevlin in, it's already been qualified.
Absolutely. Yep.
Good evening, Mr. Chairman, members of the board. For the record, John Shevlin, Shevlin, from Park Corporation. I did present at the last meeting. I know some of the concerns here, the first one I'll address is safety. We, as part of our studies, typically, the industry standard is you go back, you get 3 years of crash data for the study area, which we did. I think we presented last time, there was a total of crashes within the study area from Matity Drive down to Farnham. There's 54 crashes. 35% of those crashes were single vehicle crashes, either cars going off the road or hitting wildlife. A lot of the crashes that occurred were at Douglas Pike and Farnham, that had several rear-end crashes. We didn't show any fatalities in the 3 years that we got our information for. You know, so there may have been fatalities either before or after we got the information, but when we got the 3 years, we did not have any crashes in that area. You know, the other item that was brought up, I think, was with regards to bus traffic and such, and speeds. I mean, buses, you know, they're gonna be out on the roadways. You know, it's up to the drivers to go ahead and adhere to the buses and how they're driving and adhere to when they put up their stop signs and everything else. And I think, you know, buses should be slowing down the traffic. The speeds that were talked about, you know, we had the posted speed limit, we assumed it was 40 miles an hour. We used a design speed of 50 miles an hour because the speeds that we found were 85th percentile speed was, I believe, 47, 48 miles per hour. So we made conservative, made it 50. So we did take a look in regards to all these safety-related issues.
I think in terms of the school buses, I think the issue would be more for school buses turning left into there than if they were turning right. Because that's where, I mean, and as one of the residents stated, there are no speed limit signs. And so even 50 might be, that might be a conservative average speed on that road. But particularly, you know, school buses don't stop and then turn on a dime, you know, like my Miata does, you know. So, and if you have somebody barreling down south, that could be a problem. So could one of the solutions to that be that this work with the school department to only do right turns in and out of that, so that they're working with traffic and they're putting on the brakes, not trying to cross traffic?
Yeah, we can coordinate with the school department and the busing just to see what the routes are and what they anticipate it being.
Okay. All right.
I think those were the two main ones.
You can address them to us, yes.
Frank Rubezo, my questions are going to be for Mr. Shevlin.
Yes.
Yep, that's okay.
So my question would be, what period of time that those 54 accidents was over? What period of time?
The traffic study?
It was over a 3-year period.
Which 3 years?
It went from 2021 to 2024.
Right.
What was your 2021 to 2024? What
Yeah.
was your source for those accidents?
It's the police department.
North Smithfield?
Yes. We put a request into the police departments, and they provide us the information.
And you had indicated that you don't have a record of any fatal accidents. We know there's been fatal accidents there. So, Mr. Chairman, I just asked.
But is that, I mean, again, you try to address everything here, he can hear it, but, you know, we don't want to develop these.
There's a disconnect between.
So you feel there were fatal accidents in that time period?
There was one in that time period. There was one recently as well.
Well, yeah, but anything recent would be outside of it. I don't know when in 2024 this ended, but
Well, let me just double check. Earlier you said it was from.
again,
Maddie down at Farnham Pike.
yeah,
Yes.
yeah.
Maddie.
So again, okay. So that's something, one of my suggestions was going to be to perhaps update the traffic study, given that it's now 2 years since then. And I can, you know, I can vouch for the fact I've seen the memorial. Like, I drive that way to go to Smithfield all the time. So there definitely has been, it seems like there's been increased, at least traffic problems, if not traffic itself. People driving worse than they did 3 years ago. I don't know. But anyway. Yeah.
Another thing that people don't realize, and I live there, is they just recently replaced all the guardrails. The
Right.
state did that.
So,
wait a minute.
well, I don't know. Let me go.
Okay.
We continued the public hearing to June 25th. I would like you all, as more things are coming up, because they will as we go through this, keep track of your questions and all that, put them aside for June 25th. And sign up, and you get called in order, okay? Please.
One short additional question while Mr. Shevlin's up, if I could.
This is for Mr. Shevlin. Go ahead.
Any recommendations for this
Okay.
area, traffic control?
Mr. Shevlin, do you have any recommendations?
And then we had
what
some
the-
signage that was gonna be installed out there for traffic control. I know when we were doing this study, the DOT was doing improvements to the intersection. So they were tightening that up to go ahead and get rid of the free right turn movement that was
They-
occurring
they did,
before, which has occurred. Because we did talk to the DOT before construction started, and they made us aware of that, because we mentioned going ahead and trying to, part of this study, maybe look at to tighten that up to get rid of that free right turn movement. DOT already had it planned, and it's been constructed. So I'm not sure if that's
Well-
improved the safety out there or not, since that's been completed.
Their
but-
plan widened that intersection, made it a softer curve. It definitely had some benefits, but I think a lot of the other concerns is around the speed, what can be done to mitigate that, to monitor that, and calm it down. I don't know if there's much that can be done about visibility. I mean, you've got these hills, but I think that's something worth revisiting, because, you know, as they said, there's no speed limit signs at all. And, you know, people just, that usually means step on the gas, right?
Yeah.
So,
We can certainly coordinate with the,
Okay.
you know, Office of Highway Safety and see if,
Right.
if it's a state road.
Okay.
So like
Yeah.
I said, they just did the road over, so we could go ahead and see if they had
Exactly.
any issues with it.
Yep,
So-
all right, thank you. What else would you like to address in terms of the?
We have a transcript, and to be candid, Mr. Chairman, I think what we'd like to do is we'd like to digest it, we'd like to
Oh.
give a formal response as we've done.
Okay.
If there's any specific questions, certainly our engineer can answer them. But I think that we heard a lot this evening, and I think in all fairness to everybody, it'd be better if we put our answers together in one document.
Okay.
And we've got some lead time, a little bit more than the last
Mhm.
time for the hearing, so I feel comfortable that we can get an ample time to the next hearing.
I do have a quick question for the engineer, if that's okay.
Okay, yeah, I was gonna.
We have all of the, you did a wonderful job here laying out like the different like planned phases. Though it was brought up, there isn't for like the emergency road and the fields and anything, that isn't on any of the phases. Where would that fall into the development and everything?
It is actually on the phase
So,
one.
yeah, it's,
It's hard to
you're
see.
right, it's not colored the same colors as Phase 1, but it would be put in at Phase 1. That was important for making the connection to Leonard Drive immediately to make that emergency access. So we didn't color it because we were keeping it as open space area, but that would be done in Phase 1 as well.
Okay, thank you.
You're welcome.
Mr. Porter?
Yeah. At our last meeting, one of the requests that we had made was a cut and fill plan. So I'm going to be of the understanding that that's probably still in progress to present to us.
No, that's been presented.
A cut and fill plan?
All
Yeah, I'll have to apologize. We've gotten at least 15 to 20 emails
Right, so-
regarding this here, so trying to figure out.
The letter from Attorney Kelly's office also gave the summary of that. All
Okay.
of the grading plans have cuts and fills all on them.
Okay.
They have proposed and existing grades all throughout. So I'm not sure if there's something else. If there's something else that you're looking for specifically, I would.
Okay. It's, for me, it's hard to I know you have it parsed out with like 7 or 8 enlarged plans, so it's just hard for me to grasp just the overall aspect of it. So maybe if you guys could just provide, similar to what you've done here, an overall plan as opposed to one that's divvied up into the 6 or 7 sections that you have.
Okay.
That might help better my understanding.
That's good.
If that's okay.
Yeah, no, it's turning on some proposed layers and
Yep.
yeah, that's no problem.
Okay. I know CAD can be a tricky beast sometimes. And you have a big CAD file here.
All I was going to caution is, I mean, it's a 250 scale, it's a 300 scale plan, so turning on the 2-foot contours might get a little bit. So I'll take a look at it and try and get something that makes sense that you can look at.
That would be great. Thank you.
Because it's, it would get a little blurry once it's kind of that scale.
Okay. Thank you. I appreciate that.
And nothing? All right. I have a question. This is probably for you, Mr. Privy. Mr. Kelly mentioned that in his opening statement that it sounds like you're excavating 750,000 yards using 350 as fill and 400 would need to leave the property. And then he pointed out that on the non-conservation plan, it was 1.3 million, but with 400,000 being used. So my question is that with at least twice as much roadway, because there's more houses, all that, how is it that for that additional roadway, 50% more houses from the numbers I understand, that only, 16% more fill would be needed out of the amount excavated?
So we had to approximate. Obviously, we did not do full roadway profiles and grading of the conventional. That would have taken a lot of hours to do an entire development. So we had to take some approximations. And what we did with that is we looked at, so in the areas of where it's located. So for instance, there are the topography in different areas it's steeper in certain areas that require greater cuts in order to still have town roads that are going to be a maximum of 10% slope, for instance. So, and there are other areas where it's not as steep. So in our kind of putting together where those would be, the extra areas, for instance, there are certainly some topography areas in this area as well. But when we had it, the cuts and fills we were able to get the roadways to work in ways that the cuts and fills somewhat balanced each other.
I see.
That's what we did. We had to best, again, we weren't going to put together an entire analysis.
Numbers just do things in my head, and I have to make them all tie out. Tonight, there were a number of concerns raised about blasting. I don't recall us having conversations about blasting on this project. Is
That question had come up at some point. I did email the engineer, and he did send back an email response that it's not contemplated, but once they get into the development, that there could potentially be some blasting, and that they would follow all of the state regulations with regard to blasting, as well as state fire marshal.
Why don't we do this? We'll submit something relative to blasting for the next meeting, so you can have that.
That'd be
but
great.
I mean, I think you guys are probably pretty familiar with blasting protocols and such as well. Everything's permitted through the state fire marshal's office. Sorry, I'll slow down for you. The state fire marshal's office. Depending on the distances of where people's homes are and abutters are located and how far that is from where the blast areas would be. Pre-blast surveys may be needed, and if they would be paid for by the developer.
As well as monitoring.
And monitoring wells, they put probes in the ground, and in that instance, they would get the seismic on that. So,
but right now,
we'll put something together for you.
Right now, it's not guaranteed blasting is required. It's just, it may be, but I think if you put that plan together for us, that'd be great.
Just put a statement together so you can have it for the record, but we're not anticipating it. But again, if it is, we'll obviously follow all state protocols that we have to.
Okay. A couple of people mentioned the fields today. I think a couple of dozen, but a couple of comments on that. One, I think your comment about moving the parking area is a very good one.
We'll move that.
It kind of makes no sense where it is anyway, but moving it to a flatter area and all that, I think that's a good improvement. I would, however, say that the third field, the southernmost field, at least for me, gives me great concern. It's in one of the steepest terrain areas on the entire property, which means not only does it require a lot of fill, I mean, the disruption to, to the terrain and to everything that affects, wildlife, water runoff, as Mr. Keene brought up, it's a role model esker, and I don't know what purpose it serves. I'll just reiterate that I don't know what purpose it serves. I can see bringing it in, but unless you put in real recreational facilities, I mean, a couple of fields for kids to kick the ball around is nice, but they're going to be 3-year-olds, and they're not going to be kicking the ball around with 16-year-olds. So. But I think that third field, let's just say it would go a long way if that yellow just disappeared off the map, But I do like the plan with the
I've noted
parking
your
lot. Thank you.
opinion, and we'll talk about it, so.
Thank you.
I'm going to echo the chairman's position on that as well.
Okay, thank you, noted.
All right, and with that, I would like, I saw you take some notes when I mentioned permeable sidewalks.
So were you saying something, a specific surface that is actually or,
Yeah, the,
because what we did, we actually, can you actually go back to the last plan? It's fine, you just changed it. Right over here, we did put a cross-section on here. It was on the detail sheet as well. But we did put the cross-section showing exactly what you said as well. I'm looking at the right side, there's a roadway cross-section. And so we showed that 13-foot shoulder that is there. We showed a person. Again, there's still be some landscape. There's some street trees that'll help separate that.
Yeah,
a
and
little
I'm
bit.
talking about on the
Correct.
on the lawn side of the trees.
Yep.
Yeah.
Yeah, there is room on the shoulder. The question is, are you looking for something?
I'm looking for something that's not their lawn. That's more intended to be used for traffic rather than a lawn. I think the point about not putting in concrete sidewalks,
Right.
For a lot of reasons,
Sure.
is a good idea. But the permeable stuff, which I'm not going to take any credit for it. When the mosque did their expansion and renovations, they made an entire parking lot out of this permeable surface, so that when they have their very rare but very large events, they could turn this area into a parking lot. They can drive cars on it, but otherwise grass grows through it and all that. And of course, it's completely permeable. And there's different brands of it, of course.
Sure.
It comes in sections. It's a honeycomb, rigid plastic kind of thing. It can be, people could use their snow plows on it, whatever, a small payloader if they have
We
a
use
lot
it
of-
for fire apparatus even at some points in areas where you don't want to pave necessarily.
Exactly.
But so
And yet,
Okay.
if it's not really being worn down, it'll still look like the lawn. But I just think it's a better alternative to wearing paths on people's lawns.
I'm glad you clarified, because when you said permeable,
Yeah.
I wasn't sure if you meant literally
No.
grass shoulder, because
No,
that
no.
is permeable also,
Right.
or a more manufactured. Okay.
I just think that could be, because again, in a neighborhood this size, you want to encourage people, again, especially when it snows, encourage them not walking in the road. But sidewalks also encourage neighborhoods to grow.
I'll bring that back to our team, and we'll address that
Thank
by
you.
next meeting.
And then my last comment is just I still struggle with the order of the phases. I understood the original argument as to why you would start at the one furthest from Douglas Pike. On the other hand, I think of that means there's going to be a less than standard roadway, because you're not going to make it a finished roadway until it's done, really.
Right. Usually you bring it to binder grade.
Right, exactly. And so they're going to have that. The town's going to have to do plowing on that. The residents are going to have to drive, well, okay, maybe not at
The
first.
town it wouldn't be a town accepted road at that time, so
Oh,
the
okay.
town would not. That would
So
be up to
town-
the developer to plow. So I just want to clarify that.
Okay. Residents are going to have to drive over this essentially, semi-finished construction area, those initial residents, for years and years to come. As opposed to the conventional way of starting at the road, they're going to drive on a finished, in a much more finished way. They're not going to deal with construction. As these residents move in and they're driving to work in the morning or coming home, they're going to be driving through construction zone, depending on which zone you happen to be phase you're in at the time. And I can't help but think that there's a lot more advantage to doing it, because what I'm thinking of now, these future residents, right? Because we're, as part of the planning board, we're maintaining this rural community for our future residents as well as our current residents. And I'm just thinking what they're going to have to go through. And again, I know you have, I'm sure you have a sound business plan and all that, but we're talking about a long period of time. And who knows when the next international event might change things, and all of a sudden, phase 8 or whatever it is, phase 10 is now 20 years away or may never be built, in which case now people have this unfinished thing. They're living here, but they're separated from Douglas Pike by something that's unfinished. And whereas if you if you finish as you go, those residents will always have a finished community, even if you end construction at some point, for whatever reason. So I'd ask you to
Noted.
consider
Yeah,
that.
we'll
Okay,
we'll bring it back up and see if there's any modifications. So yeah, thank you.
thank you. Anybody else have anything? Thank all of you for, and I did see a little golf clap. That was very nice. Everybody followed it, everybody succinct and well-spoken, so I appreciate that. So unless there's anything further, we'll look for a
Motion to adjourn.
Motion to adjourn?
Oh, no, wait.
Nope.
We did the motion to continue already to June
Yes.
25th. So
Yep.
we checked that box.
Mr. Porter?
Now we need a second.
Second.
Mr. Hammond seconds. Those in favor?
Aye.
Aye.
Opposed? None? Meeting is adjourned at 9:55.
5 minutes early.
Thank you for.